First item of business, the approval of December invoices. If everyone's had time to look them over, we'll take a motion to approve.
Make a motion to approve the December invoices.
Motion by Mr. Moran,
Second.
second by Ms. Mizell. All those in favor say aye. Aye. Those opposed? Approval of the December 14, 2017 minutes. No changes. Have a motion to approve.
I make a motion to approve December 14th, 2017 minutes.
Motion by Ms. Mizell.
Second.
Second by Mr. Wiseman. All those in favor say aye.
Aye.
Those opposed? Motion approved. Approval of the January agenda. A motion to approve the agenda, please.
Chairman, there's one change to the agenda.
Okay.
The item F, Southland Christian Church plat doesn't need to be heard. It's a minor plat. Approved by the board.
So what are we doing on that?
Well, it just be stricken from the agenda. It's already been approved in office, so it shouldn't have been on there.
Is that 55 or 56? The 55.
56.
Okay, F. F needs to be.
55 was one we asked.
55 is the plat. The plat doesn't need to be heard.
Yep.
56 does.
F needs to be stricken from. So we need approval for the agenda, please.
Mr. Chairman, I move approval of the January agenda.
Motion by Mr. Smith. Second by Mr. Caldwell. All those in favor say aye.
Aye.
Those opposed, motion approved. Items for postponement and withdrawal, which would the plat.
We've got 3 items. The Raines property, item A.
Is that for postponement?
Oh, no, I'm sorry.
Nothing other than the plat that you just mentioned, right? Okay. So that's already been mentioned. Next item of business be the consent agenda, which we have 3 items, Joe.
Yeah, 3 items. Item A, Raines property. Item C, the lifestyle communities. And item G, Southland Christian Church.
So our first item for a consent agenda is FSP 2017-50, the Raines property, a final subdivision plat to divide 2 tracts into 3 tracts, leaving one 34.65 acre tract, one 15 acre tract, and one 5 acre tract located on Fennel Road. Is anyone here in objection? In objection of this application? If there's no one here in objection of this application, we'll take a motion for consent on this application.
So moved.
A motion by Mr. Wiseman,
Second.
second by Mr. Caldwell. All those in favor say aye.
Aye.
Those opposed, motion approved. Whoever's here to represent that, you will have to come up and sign your paper. Our next item for consent is PDP 2017-52, Lifestyle Communities Mills Apartments amended. It's amended preliminary development plan to add 32 parking spaces at the park area of the Mills Apartments on Magnolia Drive. Is anyone here in opposition of that application? You're here? Okay.
Concern, yes.
Okay, we'll have to hear that one. Next consent is PDP 2017-56, Southland Christian Church. It's a preliminary development plan for a 34,840 square foot church on 7 acres located on the southeast side of McClellan Circle, south of Lemons Mill Road. Is anyone here in objection of that application? If no one is here for to object that application, we'll take a motion for consent on that one.
I'll make a motion to approve.
Motion by Mr. Solsky,
No second.
second by Mr. Smith. All those in favor say aye.
Aye.
Those opposed, motion approved. Y'all can sign your papers, please. Our next item will be, Charlie, if you wouldn't mind swearing everyone in. Thanks. I'm gonna have to look at your something.
Everyone signed in to speak tonight. Stand up again, please. You swear or affirm the statement you make tonight to be the truth to the best of your information and belief.
I do.
Thank you all.
First, application be PSP 2017-51, Mallard Point Tract number 4 and Unit 1, Block A. Go ahead, Matt.
Thank you. This preliminary subdivision plat is with this application. The applicant is seeking to subdivide a parcel that's a little over 81 acres into 4 new tracts. The new tracts that they're proposing be around 20 acres, 10 acres, 38 acres, and 13 acres in size, respectively. This is located at the front of the Mallard Point subdivision in that area between the existing residential and US 25. Currently, the property is zoned B1 and R1A. It received those zoning. It was rezoned to those districts back in the 1980s with the rest of Mallard Point, the rest of the Mallard Point development. The surrounding areas are also zoned B1, R1A, and then there's also some property that's zoned A1 agricultural to the north. So just so we can get our bearings here, this roughly here is the outline of the parcel in question. North, I guess if you're looking at the screen, would be to your left. This is US 25 right here, running north and south, and then Mallard Point Drive is down here to the south of this property. As far as most of the things that we look for on a preliminary subdivision plat like this, it meets, all of our typical conditions of the subregs. The tracks meet our minimum size requirements. The appropriate setbacks are shown. So as far as things like that, there's not really any issue. I think where one of the issues that we need to discuss tonight comes up is that as part of this, when this property was rezoned, one of the conditions that was placed on it was that no development take place closer to US 25 than the 900-foot contour. And the other condition being that any development that did occur, regardless of how close it was to US 25, be screened from US 25 with trees. And when the site was developed, there were and are abundant existing trees that screen the development from US 25. I think here on this next page, I have some images that I took from online. As you can tell from these images, looking towards the west from US 25, you would not be able to tell that there are hundreds of homes just over the ridge as part of the Mallard Point development.
Matt, can you tell us where the 900-foot contour is?
Yeah, I can certainly do that. Here on this slide, this is from our maps that we have on our website. This one that I highlighted here in yellow is the 900-foot contour. So for a reference, this barn here, let me go back one slide, is this same barn that's here in this photo. This entrance that's here is one of the entrances that the applicant is proposing to use to access 2 of the lots. So that's this barn here. So this 900-foot contour, this yellow line, is what the zoning, when the property was rezoned, that was that boundary that they determined development shouldn't be closer than that line. So with the plat, the applicants are proposing that we alter that to roughly be this blue line here. While that is an increased setback from what we would typically see for this zoning district and also for even an agricultural zoning district, I think it's about 200, around 200 feet, maybe 225. It wouldn't, properties that are built just behind this line would not be screened from US 25 is my main concern. So we would sort of be, even though we would have the setback, we would lose that screening from the trees. That was the other half of that condition. So what I'm proposing here as sort of a compromise would be that we instead use this line that I've drawn in here, this straight line in orange. I've measured that on our GIS to be roughly 315 feet. It goes to the essentially the back corner of the existing barn there. And what that would do is it would be closer to the road than the 900-foot contour. So it'd be a little bit of a compromise there, but it would also preserve any of these trees in this area between US 25 and that line, so that if somebody was just purchasing the home to put a single residence on, there would still be that screening that we would be looking for. So that's my proposal. I don't know if the applicant will have any thoughts on that when it gets to their portion of the discussion. I did have some additional things. I propose that, as they establish the setback line, that we also have these notes on here that sort of preserve the trees and the character of that area in that setback line. We don't want to see any trees removed from that area. And we don't want to see any grading or construction in that area, with reasonable exceptions being made for maintaining access easements, utility easements, and the existing barn and paddocks that are in that area. Ultimately, I am recommending approval of this application. As I mentioned in the staff report, I think it is important that we maintain at least some buffering in this area. I think we could soften somewhat from that 900-foot contour, but I think it is important that we maintain an increased setback and some tree preservation in that area. I think it's important, as I have on condition 2 here, that the proposed entrance that they're showing for tract 4A be restricted just for a single residence, and that same entrance not, should a future owner own that property, that we don't sort of grant use of that entrance for commercial property, since there is a large portion of that property that is still zoned commercial. Many of the other conditions are standard. I did add, and I made it bold here on the slide, I did add this 7th condition, and that's mostly just for clarification, just to note that if you approve this preliminary subdivision plat, it renders null and void any previous preliminary subdivision plat. So in the background portion of my staff report, I mentioned that there was a preliminary plat that was approved back in 1999 that involved this property, that did still have 28 single-family lots. I think about 7,500 to 10,000 square foot. Actually, I think there were probably 10,000 square foot lots. About 28 of those. So I'm just clarifying here that if you approve this plat, any previous approval, if that goes away, and this preliminary plat would then be sort of the guide for any future development. And that's all that I had.
Matt, on that, if you move that 300, if you move that line back to that, behind that barn, does that easement up to that barn need to be brought all the way back to that too, or?
Yes. Yeah, that would be my recommendation. Just bring that easement back. Now, granted, like we see on the aerial view, most of that area, in the particularly between the creek and the road, there aren't trees. So, there's also at least 2 sanitary sewer lines that run through that area. So it's unlikely that a lot of that area would have trees that would be bound by that easement. But those trees that do exist further back around, the same distance as the barn would be protected.
So would they be able to build anything toward 25 from the 315 line?
No, not if we establish this setback.
So if I'm looking at your line correctly, Matt, and I'm looking at the map, 4B would almost be unbuildable.
I don't know that it would be unbuildable. I think it is important to remember that the single family residential zoning that it has, I would say has reduced setbacks. So there is some leeway there as far as reduced rear and side yard setbacks.
But it's R1 and B1. That's my thought, is with it being B1, it's almost unbuildable for B1.
Yeah, the B1 areas would not be allowed for residential development. Correct.
But where it says R1 and B1,
On track 4B
on track 4.
Yeah. Let me
is
go
R1
back to the
and
plat.
B1.
So.
Just a very little bit.
So yeah, I think, and this is just my opinion. I don't know, but with the access easement for that property coming here along this western side, I would imagine that somebody would probably look to build, maybe in this area here. I guess we could look at the
Commissioner Smith just
contours.
pointed out that B1 is just that sliver in that right-hand side.
Oh,
I didn't
yes.
see the line.
Yeah. Sorry. Yeah.
Oh,
This
yeah.
part over here is the only B1 part on that property. This property here, 4A, a large portion of it is B1, and so for residential purposes, a residence would really only be buildable in this back area without a rezoning.
Okay. Any more questions for Matt? Thanks, Matt. The applicant here to speak?
Brent Combs with Thoroughbred Engineering. Also here tonight is Marion Cox, the current property owner, and then Rita Jones is is helping him market the property. So she's going to have some things to say also. I thought I'd go first. Excuse me if I start coughing. I've been trying to get rid of this thing, but Matt sent me an email, and it contained a quote of some text he had found on a earlier approval, and I'd like to read that and then discuss that just a minute. It has to do with the setback and the tree preservation, because I think for the most part we don't have any issues other than that. Although this new line I think has brought up some questions that they want to talk about. But anyway, so I'm just going to read this. It's a quote. It says, "The area between the proposed lots in US 25, and of course this is an old Mallard Point approval, so it's talking about Mallard Point. The area between the proposed lots in US 25, which would typically be devoted to individual lots, has been proposed as common area that would be owned and maintained by the homeowners association. An alternative to this configuration would place the proposed common area into individual lots and establish a tree preservation easement beyond the proposed building site. Regardless of the disposition of the site, it should be noted on a final plat that the area is established as a preservation easement and prohibits the removal of trees. This would also incorporate the rezoning condition for screening and buffering as previously noted." And so when I read this, the way I interpret it, what comes to my mind is it was talking about R1A lots, like is in Mallard Point areas, smaller lots, and they're talking about when it says beyond, that means between the lots in US 25. So this, in my mind, is talking about more small lots that would be accessed from the internal streets, and that they were still concerned about making sure there's some kind of a buffering between the individual lots in US 25. The reason that's important to me is because with this proposal, we're really, even though it's R1A zone, we're treating it as if it's agricultural zone. And the access is off of 25, so it's no longer really a part of the Mallard Point subdivision. And so we still think and agree that we want to keep the screening between US 25 and the Mallard Point lots. But I would point out that across the road, we have 10 to 12 houses that are close to 25, aren't screened from 25, and of course they're in the agricultural zone. So my point is that what I would like to propose, and I've talked to Marion, and I think he's okay with this proposal, is that on this plat we would put a note that creates a threshold, and if that threshold is broken, then we have certain restrictions that we can talk about. And so my threshold would be that as long as the number of residences is less than what would be allowed in an agricultural zone, that is treated similar to an agricultural zone. Any future subdivision of these lots has to come back to the Planning Commission. So I think what we're talking about is making sure that any buyer of a lot is put on notice that if they have any intention on doing something different than what the plat is showing, that they're aware of these potential restrictions. And so that would be what I would propose. And that's, then I think, I don't know, Rita, do you want to go ahead? I think she has talked to, like I said, she's kind of marketing the property for for Marion. So they have potential buyers, and she might be able to give some insight onto house sites that they've been looking at already and that sort of thing, about how that would be affected by the 315. So I'm going to let Rita come up and talk about it. Oh, do you have any questions for me on what I just tried to explain?
Brent, you kept mentioning agriculture. None of this is zoned that way.
No, that's what I'm saying. It's not zoned agricultural, but the intent of our plat is to treat it as if it was zoned agricultural.
Are you
that's kinda
saying,
confusing.
are you saying that you would allow construction between 25 and the creek?
No, that's no. I'm not saying that. I'm just saying that I'm not sure. And I'm going to let Rita talk about this, but there are some house sites that might be closer. But I don't think anything's going to happen between the creek and 25. But I do think that there's potential that somebody might say, "I'd like to build a house just behind the creek." And so if that's in front of the 315, now that's a potential loss of that lot sale or tract sale. And I just simply point out that isn't my interpretation of all of this is we're trying to screen Mallard Point, not necessarily a single house on a 40-acre tract. Why are we doing that when across the road we're not doing that? I guess is my point. However, if somebody wants to come in.
I understand that too, but most of those houses across the road have been there for years and years before Mallard Point ever got built too, right?
Some
Is
of
that the
them,
houses
but
you're
there's
talking
two
about?
brand new
He's
ones out
talking
there.
north of there.
Which ones are you talking about?
No.
The ones at Summer Ridge or whatever it's called?
No, Alan Handelman built a house recently, and Chris Atkins built a house
But the
recently.
other ones have been there for years and years and
Yeah, a
years.
lot of them been there for a long
Yeah.
time.
Okay.
But all I'm saying, in an A1 zone, we don't have those restrictions.
Yeah. Okay.
So that's my point anyway.
Okay.
Any other
Any other
questions?
questions for Brent? Thanks, Brent.
I'm Rita Jones, and I'm the realtor for Marion. And basically, what we've got here is a 80-acre farm that's not feasible to farm. It lays up against all these houses, and it would take a architect to find all of the boundaries and to build all the fence. So Marion tried to market it as a farm for about a year with no success. So we're trying to split it up in tracts to where people can afford a home site. And we're basically only asking for 4 home sites, 4 tracts, each with 1 home. The preservation setback that we've proposed, the 200, we would propose no setback rules because it just complicates the marketing of it and makes people nervous about it. But the 200-foot setback would not be so bad because the people wouldn't be so far away from their utilities. If we come back behind that barn, you're adding another 100 feet or so to having to get to the sewer line, to get to the water line, and all the utility costs go up. And also, most of the good building sites are right along that area. You don't want to get too far up in those hills because of the steepness of the hills in order to build. And our other concern that just came up tonight was we didn't know that you couldn't build on a B1. We hadn't been advised of that. We haven't asked for it to be downzoned to an agriculture zoning, but more or less, as Brent pointed out, that's how we're utilizing it. We're not going to put more than 1 house per 5 acres. We're not putting even that. We're only proposing 4 houses. So it's just a matter of the property's old use is no longer being used. It's no longer a buffer for Mallard Point. It's not feasible to farm, and therefore the best use for this property would be home sites, and we're only asking for 4. Anything else you want to add, Mary?
Joe, can I ask a quick question? I think I asked this the other day. Does that have to be done by a zone change now for that B1 to go back to
Yes.
R1A or to A1?
Yeah. Planning commission could initiate it, but it would have to go through a public hearing to be rezoned.
public hearing that would have to be advertised and all right.
We looked into that, Steve, and it was so costly and time-consuming that we didn't want to do that. And Marion just pointed out, right across from the driveway, there's a brand-new home that hasn't been there very long.
It's
Another problem is that it's already been zoned B1 though, and it has, in order to build on it.
I don't think anyone is going to use the B1 zoning. I don't know of any business that would be suitable
Right.
for that area.
Right.
And of course, if anybody did want to use the B1, they'd have to come before the bodies to get that approved. We have no intention of using the B1. And the B1 is much bigger on this plat than it was when we originally looked at this. The original plat that we looked at Planning and Zoning just showed it a little bit past that Block A. And now it's half of Track 4A, which was not our original information.
And 4B has just a little bit of B1
Yes.
in it.
But if you take away the B1 area off of Track 4A, there's no place to build on that.
No, you'd be in some
Right.
some steep area up there, I'm sure.
And if you use the 315-foot setback, as you stated, Mr. Solsky, you've severely inhibited Track 4B from being built on. So we're just trying to do some common sense and some what would make sense for the seller.
You made a couple comments, Ms. Jones, that the land really isn't farmable anymore. What makes it not so farmable anymore?
All of those houses that you join, you would have to find each one of those markers and build a fence
Okay.
all the way around all of those houses. And technically, all of those people would be subject to a cost of half of that fence. So the only farming that you can do are the paddocks in the front and the horse barn. And the people that we've talked to about buying, that is their intentions, to use them for some kind of small animals. Maybe riding horses type thing. But as far as any cattle uses or anything else, you've got a lot of wasted land there. The majority of it would be.
Then you made another comment of pushing the line back, that you wouldn't want to try to build on such a hilly slope. Last time I was at Mallard Point, just about every house out there is built on a hilly slope, so.
I understand that it
I don't
is.
understand that comment either.
But their utilities are a lot closer. Your utilities are over here on 25, so that would be a cost that we would like not to have.
I can understand
And their
that.
driveways, they've got to build their driveways.
I can understand that, but most people that's gonna buy a 40-acre tract is not gonna worry about a few $100s more in a utility cost.
But they still want to build close to the horse barn because that's where they're going to have their activities, is in the horse barn.
Okay. Any other questions, Ms. Jones?
Yes, I'm a little confused about, you said 4.
Four homes, one home per tract.
Now, is that on track, oh, you mean one on track 4A, one on track 4B, one on track 4C?
That's the way we're marketing it. It's just a single-family home. And Marion has asked that those homes be built to the same specifications as Mallard Point so that it will not deter from Mallard Point.
The question is, on each of these tracks, could the house be, how close to 25 would the house on each of those be built? Is that the question we're considering?
I think that's up to the people that are buying normally.
But that's where we're going to draw the line, on those
Right.
3 lots.
And if we have to have a preservation line that requires it to be in a certain place, we would like to stick with the 200-foot line because it makes it not so onerous to the people that are buying. For utility move it, common sense place to build a house, that type of thing.
Okay.
And the B1 zoning situation, we need to address that.
Yeah, that's what I was looking at,
And that was news to us
4A,
tonight.
track 4A.
Yes. It's half
So to
B1,
build a
all the
house, you
front.
would have to be way up here on this back
Yeah.
part, which the only entrance you have is off of 25.
Right. So that's
That's
half a
pretty
mile
good.
of road?
It's a pretty good road, you gotta
Yeah.
build back through that one.
That was another question I had. You say that there was a lot of expense in having that rezoned? What,
If we ask to have it down zoned to an agriculture zoning, it's the time and the expense of
Of that.
this meeting and fiscal court and all that it would take to do that.
Yeah, but that's the only way it can happen, isn't it? I think, I mean,
On the back part.
Like I said, that B1 information is new to us tonight.
Y'all didn't have this plat?
We had the plat, but no one ever told us you couldn't build on the B1
On
until
B1.
tonight.
couldn't put a residence on.
Oh, you couldn't put a residence on. You could build
Yes.
a business, but you couldn't put a residence.
Right, that's news to us.
Any other
So
questions for Ms.
we would
Jones?
ask if you could, if there's any way you could have that done away with.
Charlie, that's a legal question for you.
That's something that I probably shouldn't say many, but there are certainly a large number of zoning ordinances that do permit that.
To retract
Something
back.
of a less
Lesser.
intensity on a particular, we don't have that, we've never had that. I'm not so sure we've ever actually prohibited it. I mean, it makes sense that no, you can't do it on B1, but I don't know that we've ever prohibited that. But on the other hand, I haven't gone back looking through the records, but I don't remember that.
Are you saying we've never allowed
No,
a
we've never
residence to be?
prohibited somebody from putting a residence pretty much anywhere, because it's a down zoning kind of thing, and there are many ordinances that say you can do that. Ours just doesn't say that. We've discussed it excuse me, a time or two, and we've never had, it called for us. We really never really proceeded with it or even reached any kind of conclusion.
We don't have anything to say that, if it wants to revert back to its previous zoning.
We did that a couple months ago across the street
Yeah,
and
but we still
converted
had
it
a-
from R1 back to ag,
We still
remember?
had a- we still had a
had to have a
hearing on
hearing,
it.
though.
That was a hearing, yeah.
Yeah, we had to have a hearing.
But there's nothing that says, because it seems like, going back to A1 would be most preferable.
Yeah, I think clearly to go back to that, I think that would require a zone change.
Okay.
It's just that I'm not so sure that we've ever said to somebody, well, that's B1, no, you can't build a house on it. Once upon a time, they just stuck B1s in a number of places around the county, and I assure you, we've got houses on a number of them. But that's way back in the dark ages. But ordinarily and technically, if the ordinance says it's for A, B, and C, and single-family residence isn't there, then technically, no, our ordinance doesn't permit it.
That answered your question, I guess. So, all right. Did y'all have anyone else to speak, Brent, or? Yes.
Go ahead. Go ahead,
Good evening. My name is Bruce
Are you with
Coombs.
the applicant, or?
Pardon?
Are you with the applicant?
No.
Are you with the applicant?
Yes.
Yeah, let's let the applicant finish
No
first,
problem.
please.
I did, Charlie, you need to swear me in. I didn't sign up because I hadn't participated in a lot of the preparations. I do represent Mr. and Ms. Cox, Harold Sims, so,
Do you swear or affirm what you're about to say is the truth, the best information, believe?
yes, sir.
And I'll
Yes,
put it
Charlie.
You probably like that.
I didn't believe it for a minute.
I guess the revelation, I think that what was news to me was the ultimate size of the B1 zone. I thought the B1 was much farther down in relationship to the track that was just so next to Mallory Point Drive. But in regards to I don't know that it speeds the process up and it doesn't help us, our marketing in terms of time, but in terms of movement, expense, and it would appear to me that this board would not have an objection to the removal of that B1 zone. And it certainly is part of the KRS 100 in our zoning ordinance that the planning commission can initiate that zone change. So the planning commission could, the applicant could award the fees and expenses for the filing of it. If the planning commission were to initiate the zone change, the applicant then could pay the cost of the advertisement for the meetings, have the public hearing, and then get to the legislative bodies with a zone change proposal that was initiated by the planning commission, assuming that it got through the public hearing and had an affirmative vote. Certainly not the marketing that the applicant thought we were going to proceed with, but I believe that if we had the planning commission's tacit approval that you would see with initiating the application, we could be a little bit more aggressive in our marketing to say this is all going to be, ultimately all going to be A1 or R1A or whatever you chose to move it to. But and then getting back to a little bit of what Brent was proposing, he was simply trying, I think, to self-impose the A1 density on the criteria to honor that 900 foot setback. If our plan is just to sell it to 4 single-family lots. If somebody that bought one of those lots then wanted to subdivide it, and we put on the plat that if you're going to go any density more dense than an A1, you'd have to come back before the board. So I think Brent's ultimate suggestion gives the board some added protection in the event that somebody that we sold a lot to, with the idea and the marketing plan that we were only selling one, a 40-acre tract to one person, if he ultimately wanted to turn it into 4 tracts, or in more than a A1 density, there would be a restriction on the plat that would have let him know he needed to come in. And so you're even though we've got some zoning in place that would even be more restrictive than that, we were going to self-impose another restriction on ourselves. But I do think in regards to the development of the size of the B1 tract, Planning Commission initiating the zone change and us, the applicants, moving along, I'm sitting here wondering whether a conditional use permit would work, but I would have to go back and do some research on that. But I do think that the ultimately legal fireproof way would be to do an official zone change, and that can be started with an initiation by the Planning Commission. Thank you.
Do y'all have anybody else? All right, we'll take the gentleman now from the audience.
Thank you. My name is Bruce Kuntz. I'm the president of the Mallet Point Owners Association board member, and I'm here tonight speaking on behalf of the board of directors. Some interesting conversations, some new news, obviously, as we're going through. So I'm going to break this down. My notes obviously have changed a bit as I've been listening to the group. In terms of the proposal to subdivide this 80 some odd acres into 4 parcels, the board of directors has no objections and is supportive of that. The question and the issue of having these as R1A 4 plats is also, in my opinion and the board's opinion, would be very supportive. We would also be supportive of trying to get that B1 converted by whatever process is appropriate into a R1A. So our interest in supporting this is that those 4 parcels remain R1A or can be converted in the case of 4A into R1A, and also the preservation of the trees, which I believe has already been being discussed. If there's any questions, I'll try and answer any of that again.
How do y'all feel about the new line, the 315?
This is new, and candidly, I haven't had a chance to look at it. Let me ask clarification, because again, this is not my area of expertise. That setback is that no building could be built further than 315 from the street, US 25.
No closer to US 25 than that 350.
Without having looked at it, 25 or 350, moving that line further to US 25, I don't know that we would have an objection to that. I think our concern would be more on the backside, trying to preserve that section on that, but moving it closer to US 25, I don't know that we would have any concerns.
Okay. Anybody have any questions, Mr. Guns?
I have one question for probably the staff and for everybody. if we're gonna go to the trouble of rezoning this B1 to R1A, would it not be good to rezone all of this just back to A1? And back to R1A would still allow several houses, wouldn't it?
I guess I would, that would be my preference, is if we were to rezone the property, that we seek the A1 zoning that would allow them, that 5 acre density that Brent was talking about. It also would offer us an opportunity to sort of revisit this condition as far as the setback, and in some ways would allow us to revisit that issue with the 900-foot contour, and whether or not that's appropriate. And I think it becomes more appropriate to reduce that maybe to the 200-foot line, if we have that zoning guarantee that the 5 acre density is as dense as that will get without a further public hearing.
Yeah, I'm kind of agreeing with Stephen on that, trying to get it back to A1. But also, on a new floodplain, where would that line be at? Did you ever do a layover on that?
Yeah, I looked at it, and I mean, Ben could confirm this if he
Yeah, that's probably a question.
remembers.
for him.
But I don't remember that the 100-year floodplain showed up in this area.
There is nothing out there on there.
Is there any benefit at all to this remaining R1A now? I mean, for Mallard Point subdivision or for? I'm trying to think.
No, I mean, to my knowledge, nobody's really tried to develop this area as an urban style residential or commercial, since the last plat in 1999.
Question I have for you, Matt, is
Yeah.
Monday at the workshop, you presented the 200-foot tree preservation easement. We did talk about 225, which would have probably taken the stream completely out of
Yeah.
the line just beyond that. Would the 40-foot front yard setback be then 40 foot from that line, or it would be you could build right on
You
the
could
line?
build right on the line.
Because I mean, I would, if I were to, I'm not gonna, but if I were to be a purchaser of one of these lots, and you put that line right on the edge of the creek, you would think no one would build there, right on the creek. But for that track 4B, as I mentioned earlier, you put a 315, which is just beyond that horse barn. I guess you could build in that one little corner there, but you're really kind of tightening the screws up a little bit.
Yeah. I mean,
the other thing that I don't know if you pointed out that, but this 25-foot sanitary forest main easement zigzags well beyond the 200
yeah.
foot.
At times it comes to the west of the stream.
Probably about 230, 240
Yeah, it's
maybe.
I think, with regards to your question about the building sites for track 4B, it is possible between, should you approve this application, it is possible for the applicants to adjust some of the property lines, between this hearing and, and the final plat being recorded. So if there is a building site that they want to try to sort of shoehorn into track 4B, I think that would be acceptable.
And we keep talking about these are going to be 4 houses, but there's not anything that would, we're not writing anything into this that would stipulate that only one house can be built per lot, are we?
Well, the zoning does that already. The R1A is our most restrictive single-family residential, and so only one residence would be allowed per lot as it stands now. They would have to subdivide if they wanted to put additional
If you go
homes on
back
those
to
lots.
A1, yeah, if it went back to agricultural.
If it went back to A1, that has the same requirement of one dwelling per lot. The difference being that if somebody wanted to subdivide to get additional lots, the A1 has a 5 acre or one dwelling unit per 5 acre density, whereas the minimum lot size for the R1A is 12,000 square feet.
Charlie, legal question. Without us making any zoning decisions tonight, would we have to table this applicant and make them apply for rezoning and have them come back?
Contingent upon, just make it contingent upon
Because
the,
I don't want to decline it based on zoning, but if, for the benefit of the applicant and us, would we table it and let them go through the zoning application?
Well, as I understand it, and I've got to be, I don't know how many decades I've been here, but I've never heard a question like this one before. Usually we're trying to squeeze stuff in, we're not trying to open stuff up.
More intensive.
So, all we're doing tonight is a preliminary, an amended, well, a preliminary subdivision plan, we'll forget about amending it, but a preliminary. I don't think the zone is at all relevant, other than, of course, we've got the vision of where they're headed with it, and that will, I believe, require a zone change on 4A. But otherwise, I don't think that's really affected by it. So you can approve the preliminary subdivision plat. They can begin marketing in a sense, but it's gonna be kind of a complicated marketing because they've gotta show subject to, what we're doing down here.
So if they want a zone change, we can approve tonight, and then they can apply for a
That's
zone
right.
change for 4A
For 4A.
at a later date.
Well, and for a piece of 4B. Yes,
Yeah,
sir.
that's sliver.
Yeah. So I don't think that really changes what you're asked to do tonight. The only thing specific other than that would be then the discussion on that setback line. Because I think that would be appropriate to fit. And I've been trying to figure out why that's appropriate, and I think I agree with staff after I've sat here spinning it way too many times. Because all of these were conditions set on these properties, and even though this will not be built as a part of Mallard Point, it is still part of the real estate subject to those same conditions. So those same conditions would otherwise apply unless you make that alteration according to staff's recommendation, or you do something otherwise. So I do think staff is absolutely correct on that, and I think the zone change requirement is correct. But as far as tonight goes, you can approve the preliminary subdivision plat with all the zones and all in the same place, but I do think you need to add that setback line.
I had a question. If the applicant, if Mr. Cox here were to decide to do a rezoning, I guess our question would be, can we still get that on next month's meeting? Because that would have an effect, I think, on his decision.
Well, a zone change hearing itself,
We've missed TRC.
You've got to have the notices and all that, and it's, 14 days, I think, isn't it?
Yeah, we can meet all that. We've essentially missed the TRC meetings, is what we've missed.
Well, I think that probably something staff needs to discuss as to whether in this situation that's critical or not.
Is TRC important for this, or is it just a zone, it's a lesser?
If they're asking to go to A zone, we would need to go through TRC.
So we could make,
Either one,
I was thinking that it probably wasn't really critical. But if not, then part of your motion tonight could literally be and waive TRC so they can make every effort to get their zone change on for next month. Because it really should be, I mean, gosh, we're going in the right direction.
Going the opposite.
Yeah, we're going in the right direction, so that ought to be one of the easier ones we'll ever do.
Matt, on this plat thing,
Yeah.
one of the notes on it, number 6, says all residential lots need to be screened from US 25. So if they ever build, would they have to screen from US 25?
Yes, unless there's existing trees that would screen the building already. I mean, much like with
Yeah, just landscaping.
yeah. I mean, if a
Yeah, but I mean
development in
trees.
town builds
What-
on a site
I
and
mean,
preserves
what
trees.
would be the lot? I mean, that one is 40 acres. Would they have to screen the whole front of that 40
Screen
acre
the house,
lot across there to,
I mean, you just have to screen the house,
okay.
just the house, not
What
yeah,
says
not,
the lot?
Oh,
All residential lots need to be screened
Yeah.
from US 25.
I think with that note they were talking more, kind of like Brent mentioned. They were talking more about if the lots were ever subdivided to a smaller size. If there were lots that were the same sizes that are in Mallard Point. But we can clarify that language.
Yeah, I'm just reading the note.
Yeah.
That's all I'm saying. Anybody have any questions?
Well,
Questions?
could they go ahead and market 4C and D if we approve it, without, before the zone change goes on.
4D as well, isn't it?
Sorry, say that again.
They could go ahead and mark it 4C and 4D if we approve the
Yeah, because they're
preliminary
already-
plan. And then they don't have to worry
Yeah, I
about
mean,
the
I mean,
others that could be rezoned.
if the preliminary approval, I mean, they could market any of them. I did have a question actually for the commission. When we talk about initiating the zone change, are we talking about just for the commercial area, or are we talking about the entire site? Because, I mean, my preference would be the entire site, because, I mean, I would make the argument that the R1A zoning itself is even somewhat inappropriate if it's not going to be developed as a part of Mallard Point.
I agree.
I agree too.
How do you all feel about that? If you're gonna rezone one, should you rezone it all?
Actually, we would prefer not to do that because of the cost of notifying all those people that own those houses all along through there. And they tend to get a little excited when some neighbor is rezoning. And they've already been excited thinking we were asking for B1 zoning, which we are, of course, are not. We would ask that you would approve everything but 4A. There's just a small sliver of 4B, and it's not even close to where the access road is going to be for them to get into that. So if the only one we had to rezone was 4A, and if we had a determination about the setback, we could go on with the marketing of 4C, 4B, and 4D.
The only thing I'm concerned about is that somebody's allowed to come in there and try to develop this as R1A and put 40
But they have to
lots.
come back to you, don't they, for that?
Mm-hmm.
Because all we're asking is one single-family house per lot.
Could I ask a question, Mr. Chairman?
No.
Assuming for a moment you do the setback that you suggested tonight, if that's the setback and it's left at R1A, how many lots could actually be gotten on it? Because most of this is going to be beyond that, it's going to be beyond screening. I mean, some of those things are not going to really have application anymore, I think. I mean, can you get a significant number of lots beyond that setback line?
I mean, for R1A?
Yeah,
If
if
they
it's-
reapplied, according to the way I understand it, but they'd have to reapply.
Well, for a subdivision plat, but I'm just saying, if there's a finite setback line, would that pretty much eliminate at least very much potential for subdivision of R1A lots?
No, I mean, you want me to answer that?
go ahead.
Well, anybody?
Yeah, I mean, if you look here, I mean, the 900-foot contour that they have on here was more restrictive than what I'm proposing, or the applicant is proposing, and there were still going to be, at least 28. There's currently preliminary approval for at least 28 more residential lots on that area, with lots of open space still available for common area.
So you're saying 28 more houses could be built with the line moved up to what you said today?
Yeah, I mean, yeah.
In theory?
Yeah.
Yeah.
I mean, currently, yes, there is a
Versus four.
preliminary approval for another cul-de-sac, much like this one, to come out of this area and develop into this area. And that doesn't really even mention, this area and these areas over here that could also potentially develop. And that's why I suggested that if the applicant isn't looking to develop that, and we are initiating a zone change, that we could just change the zone of the entire thing, since they're no longer, wishing to develop as part of Mallard Point.
I wouldn't think that anybody would object to that if you're going to a lesser
No, I
use.
well, I mean, we could ask the gentleman from
Yeah.
Mallard Point.
I do realize there's gonna be a burden, a lot more people to contact. I think the, as it stands right now, you have to contact within, what, a 500-foot radius? Or
1,000 feet outside.
It's gonna affect everybody, it's gonna take in the same number of people. Almost. That'd be a few more.
If I may just clarify, based upon the conversations that are going on. As I said, the board of directors and I'm sure the owners would have no objections to downgrading the B1 to an R1A. If there is a proposal to rezone this all or part of this to a 1A, then we will strenuously object, because that opens up a whole can of worms.
You would
You mean
object to
A1?
what? To
Or
the
A1.
A1?
R1A, we're fine with.
No, I'll say back to A1, agricultural.
Then I think there'll be a considerable objection.
Why would there be
What would be
objection?
objection on that?
That's what-
Because then what we're supportive of a single-family residence as it being marketed, we're happy with that. We have no concerns. If we take it back to 1A, and then it raises the potential for having a subdivision going back, still has to go forward, or more homes on 5 acres, I think you said 5 acres? on agricultural 1A, and I think that will raise a concern within the organization. So
You'd rather have 28 houses instead of,
R1A.
you'd rather see 28 houses instead of on a 40-acre tract having 8?
No, what we're saying is we're supporting what Mr. Cox is proposing, is 4 tracts as basically R1A, 1 home per tract. We are supporting that.
Yeah, but there's no guarantee there's gonna be 1 home per tract.
Well, unless that comes to a subdivision.
Unless it comes up
in which
here.
case it comes before you, and
And
then
even on the,
there will be an
even on
objection.
A1, it still has to come here.
We understand, but what I'm trying to tell you is it'll be cleaner if we can just get it to R1A from our perspective.
I disagree with that comment. I just disagree.
Now,
I think what Commissioner Jones is saying is if we leave it R1A, once Mr. Cox parts way with the property, there's nothing to stop 28 homes being built there. If it goes to A1, the max it could be on there is 8. So I want to make sure you understand that.
Contract, you're just talking about on,
And it'd be minimum 5-acre lots at A1. If you let it go R1, it potentially could be 28 lots. And there's nothing, but they'd still either way have to come back to us.
Either way, it has to come back to you. Right.
Either zone has to come back.
Yes, that I understand.
The only issue we have with the zone is the B1.
The only is B1.
It's the B1.
Yeah, that's the only lot that we're concerned about.
And we were fine to live with the B1 as long as we could build 1 house on that lot.
That's right.
But if Mr. Perkins thinks that there's houses on B1s in the county and that that's appropriate, we'd be okay, but
I'm
if
just
it's
saying
not.
we've never stopped that. I'm not saying that it was probably appropriate at the time.
Charlie, you've been here a lot more years than I've been.
Wait, too many tonight.
Have we ever initiated a zone change and not an applicant? As a
Oh, yeah,
commission?
oh, yeah.
We've done it.
Oh, yeah, we rezoned the Maddox area, the Oldham lumber area, a big part of Bourbon Street, Midland Avenue. Oh, yeah, we did.
Well, I mean, instead of an applicant.
Yes,
Seeing that the
there was no
applicant-
applicant there, that we initiated that. There was a significant amount of property that was, we felt improperly zoned, and yes, we initiated that. We sent the notices. We, of course, conducted the hearings, but it was, if you will, staff was as if they were the applicant. There were no private applicants there. And that involved a ton of property owners, not, as in this one property owner, so.
What would be the benefit of the commission initiating the zone change versus the applicant, besides the expense? Well, they'd still have all the expenses.
There is no difference otherwise. It's the exact same process. Statute just simply gives us the authority. In the other case I'm referring to, we wanted to change the zone.
Right.
A lot of individual owners probably didn't mind it. Some didn't care one way or the other. Some liked it.
I thought it was liability and cost, and that's the two things.
Oh,
I
that's
was-
really all it is.
In this case.
In this case, yeah.
No different liability, no different costs, still notifications have to
Still
go
got
out.
notified, still got to publish, still got to have signed. I mean, it's really the exact same thing.
Charlie, if we leave it R1, B1, and they put a house there, who would stop them from building that house? Is there any way they could be stopped from doing that?
Any way they, well, sure, because the zoning ordinance says in B1 is neighborhood commercial.
But who would
And-
enforce that? Building inspector when they
That's
apply
us.
for the building
That's-
permit or
That's us
something?
primarily.
when they went to get their.
County enforcement officer could, building inspection could.
Could, okay, so it's
Or
possible to
it
do.
could well be as simple as building inspection would say, we're not going to issue you a permit.
Okay.
Because it's B1
And
and
that would not be clean then.
so as I said, I don't think we've ever done it, but it
Could be
is
done.
fraught with some
I'm
problems.
sure the applicant wouldn't want that option out there.
Brent, or Ben, either one of you guys could probably answer this. That sewer main says two force mains, so we're seeing the two dotted lines across there. How far can you build right up to that line? Is that what that means?
Well, any easement, when somebody requests an easement, that easement is to be what they need. And so they're saying, we don't need anything past this, so yes.
So the
You
dotted
can,
line
you
is
can
as
put a
close
building
as you
right
can
up
go.
against an easement line.
Okay.
Which makes no sense then to leave that easement where it's at, because it's right in the middle of the creek, currently, at 200 feet.
Right, the one
talking
force
about the
main is
sewer
actually
main.
along 25 along with the water line. The other easement I actually have drawn on that plat. I don't know if you can see it, it's kind of a zigzaggy line. And so one option Marion had was just use the back side of that easement, because certainly can't build in that easement anyway. And it's on the far side of the creek, so that gives you the creek bank, and then another strip of easement before a building site could be. So that's an option that he's asked me to put forth.
Does anybody have any other questions for applicant or staff?
I had a question.
Does
for
anybody
staff.
else out there want to speak on this application?
Will this still be an R1A? If somebody comes in and seeks to put houses in that area, as if it is R1A, they could put a house on every, 12,000 square foot lots, correct?
Yes. Yeah. I mean, if.
But they would have to
if
come
they-
back to us
if-
to seek approval for that.
Yeah, I mean, they would come to you for approval, I mean, as long as they abide by, the zoning ordinance, the subregs, and the, the conditions under which the property was zoned, you'd probably have a difficult time turning down any application that met those conditions.
We can't put stipulations on this that only one house can be built per lot right now, can we?
I don't know that you could do that greater than what the zoning already
No,
already
we couldn't do
regulates
that.
it.
They can certainly sell it
I mean,
with restrictions
Yeah.
that they put on it.
Yeah.
Yes.
Right. Yep. I don't guess it makes any difference.
Does anyone else have any comments, other comments?
I just wouldn't want to ever see that, since some of these lots don't have access through the other entrances, if somebody actually tried to put a development in there, then you'd have another main road coming in.
Well, and that's why we probably do have some interest, other than just convenience and whatnot, for the current owner, some interest in maybe initiating his own change. Because it would be kind of nice to kind of close off Mallard Point right where it is.
Yeah, keep that buffer.
Yeah.
Do you think it'd make more sense then to table this and wait for the zone change and truly vote on it as A1 instead of R1 then?
Well, if the basic lots are gonna be the same, again, I don't think it makes any difference for that.
But if you approve it as an R1, again, once Mr. Cox sells it, there's nothing to stop somebody from dropping 28 homes on there.
Well, I know that's true. That's why the zone change, they would need to go ahead and proceed with it.
Now,
But we couldn't make it a condition of approval to make the zone change mandatory.
Well, and, we can't require that, but they've stipulated that, and so because of their stipulation, that's part of the basis for our approval of their proposed plat, sure.
Can we make it a condition?
Sure. And if they probably turn around and sued us, I'm not sure we'd win on it, but we treat it as they've stipulated that as part of the inducement for our approval, and we accept that stipulation and approved it.
What are you talking about, zone change?
Well, to me, my fear is if we approve it, Mr. Cox sells it, and whomever buys this, especially this 38-acre lot, they decide, you know what, we want to put 28 homes there, we can't stop them.
What are you talking about, zone change? What
To
do you want?
A1, if you do it to
But the
A1,
applicant doesn't want to do that.
but if there's only one house supposedly being built there,
I'm just saying.
it shouldn't be a
You just-
problem by
didn't
the
you just
applicant.
State that y'all would prefer not to do that? Not to go back to A1?
If it all went to A1, is there any difference in that and R1A?
Not if you're building one home, but if you're thinking of building 28 versus,
Yeah, once it goes back to A1, it's highly unlikely they're gonna get a zone change back to R1A.
correct.
So yeah, there's a huge
That's
difference.
my argument,
Yeah, there's a huge difference. If it goes back to agriculture, I can't imagine it ever coming this way again.
If they truly want to, their intentions are one home on each lot, then there should be no
That's-
issue not to have it converted back to A1.
Except for the cost.
Well, there's gonna be some cost just because it's one lot, so all you're doing is making a slightly, the same radius, it's still a 1,000-foot radius around this area. You still have to
If
contact
the
everybody.
1,000-foot radius will now then come,
It'll take
you
care
know,
of more
2,000
people.
feet over. You're including a whole lot of extra property.
I guess if I lived in Mellor Point and I was told that there was possibly 4 homes gonna be built outside my subdivision, and then all of a sudden land starts changing hand and somebody gets an idea that, hey, I'm R1, I can go ahead and build 28 and there's nothing we can do to stop them. Why not change it?
I agree.
Well, I agree, but still, you've got the expense of the publications and notices and all of that.
May I comment, please? And again, this is not my area of expertise, and I'm speaking without having a conversation with any of the other board members. I believe I can speak on behalf of the membership saying that our goal is to have the fewest number of homes there as possible.
That would be A1.
If it's A1, I think as an organization, our preference would be if the land could be sold with a restriction of 1 home per lot, that would be the ideal. The second most attractive would be the 1A maximum of, well, I guess 1 home per 5 acres.
5 acres, yes.
So my first one is the restriction. I don't know that has to be to Mr. Cox, and whether or not that can be done. But if not, then if the next best option is the R1A maximum 1 home per 5 acres, I guess that would be the next best option for us. The worst thing would be to go and have X number of homes there, whatever X is. And I
You
think
can
that,
have, with R1A, you can have a house every 12,000 square feet, so
that's the reason why I ask your indulgence to let me come back up and address you again. As I'm understanding that, as I said, my first preference is to have a deed restriction that says 1 lot for that, assuming that's legal. I think it is. And if not, then the max going to the 1A, which keeps us at no more than 1 per 5 acres, would probably be the next best option then, in terms of the board's opinion.
Charlie, as our legal counsel, can we restrict 1 house per?
we can.
We can't. See, that's the problem,
No,
sir.
we can't do that.
Well, they can say that, but they really can't. Once it's sold as an R1 property, and there's nothing they can do as a realtor or Mr. Cox as a former owner. Once he sells it, it's out of his hands and hers. Because the restriction's not up to a realtor, no offense, ma'am, or the former owner. It's based on how it's zoned, either currently or if we have to rezoned as A1.
May I ask for a clarification? On a deed, and if a property is transferred to me for sake of conversation, and it has a restriction of, I'm transferring you to this, but someone that next to you has the right to join the organization. You're saying I don't have to abide by that, as if it's illegally filed?
When you say join an organization, meaning the HOA, that's one thing, but to have a restriction on a 40-acre lot that says that you can only build 1 house on there, Charlie, you can't put that on a deed.
Well, they can have private restrictions and private covenants, their own contracts. When we look at it, it's R1A, and they can have lots of 12,000 square foot each. And we can't enforce their stuff.
No, understood. That would be they as the sellers and the.
Yeah, that's why the only real safe way of doing this is to have a zone change.
So Charlie, can we approve this application with the condition
Yeah.
that a zone change is being initiated by the board?
Well, again, if they were to stipulate that that's what they're gonna do, then we can incorporate that as part of our justification for it. If they don't, I mean, it satisfies our rules. So we really don't have a basis for turning it down when it satisfies our rules. We don't have a whole lot of discretion about subdivision plats. If it, they got 10 rules to follow and they follow all 10. In fact, most places it wouldn't even come here. Staff would sign off on it. I mean, we just don't have that kind of authority.
So,
Can we
Mr. Cox-
approve it under that condition?
Oh, yes, sir, because
Okay.
apparently they've satisfied everything that they need to satisfy as far as the subdivision plat.
Would that satisfy the applicant if we approve the plat with the condition that we are initiating the zone change? in the
It
R1?
would too, except for one issue. Mr. Cox has decided he will request an A1 for the whole thing, which I think will answer a lot of questions about density and future density. But with that, do we still have to have that 200-foot tree preservation, since all other 1A in the county does not have that?
I think it'd still be appropriate in front of Mallard Point, though. I mean, that's,
Now, we're talking about down in the creek area, the houses are way up on top of the hill, the Mallard Point houses are.
So, if I may ask a question, just to make sure I'm understanding, you're not talking about any of the trees that screen Mallard Point.
No,
You're talking about what's down front.
that's the required tree preservation area is the down front. There's no trees down there anyway, much to start with, but it's affecting where people can build a home, just the home site.
If what we're talking about is all the trees that screen Mallard Point would stay, even the ones that are on your property that's going to be rezoned A1, and all you're asking about, or would we then have screening requirements for your property, the A1 property? That is problematic because we don't have screening requirements for A1 property. And I think only because of reliance and whatnot on what's gone before, we would say no, but you got to preserve them on the backside to screen both to and from existing Mallard Point. Because it is kind of difficult to require something of an A1 property that we can't require on any other A1.
What if we ask, keep the
Would that be
200-foot
A1?
line,
Could be A5.
or
Yeah, it'd be something
The-
else, yeah, because that doesn't have it.
sewer main easement, which one is greater from 25?
They're close to one and the same,
I
but
mean, sometimes
but-
the easement jump past, it might be 215, 220, I don't know.
I just didn't know if you could ask that with an A1 zoning.
Actually, I think, Joe, this would be an A5, wouldn't it, for 4 lots? Where is it? Is it beyond 3?
Well, it's less than between 5 and 10, so it's,
It's less
3
than
or more between 5 and 10, so there's a couple of them over 10 acres, so it
Okay.
would be A1.
Charlie, could we ask that 200-foot line if we do a zone change to A1? That's a good point.
Boy, that's a good point. I would probably prefer they stipulate that as part of their application, because again, we don't have that rule for A1. But that would certainly be a very nice incentive to us to grant the zone change. Not that we wouldn't otherwise, but it'd be nice to have that as their stipulation, yes.
What,
Are you guys willing to stipulate that?
what's being gained if you do away with the tree preservation area there? Just because it's A5?
just so that people can build kind of where they want to.
But wait a minute, it's
They
not
can
gonna be
build in front.
A5 unless they ask for A5. Otherwise,
Right.
it's just gonna
I
be,
mean, A1.
it's gonna be A1.
I think the benefit of having that 200 foot tree preservation easement would then not allow anybody to build in front of the stream, because that, I mean, it'd be kind of really close to the road there.
Well, that's US 25, they gotta have a 100-foot setback anyway. Where's that in relation to
So
the
they-
stream?
You could do it.
It's
You could-
halfway between that.
yeah, it's about halfway.
Yeah.
Oh, it is, isn't it? Yeah, it's at the back
You
of
could
the
put a
road, yeah.
small house in between the stream and the 100-foot setback, and it would look terrible, but
And get flooded.
yeah, get flooded, be close to the road, and it would look terrible.
Right, we understand that.
So that 200-foot
The
setback.
difference between the 200 and the 315 does get to be a problem.
Would you guys be willing to do the one I asked for, like the 200-foot or the force main easement, whichever one is greater from 25 at that point?
Force main easement is
Because sometimes the force main easement's a little bit further.
Looks like about 225.
Would that be okay?
It's only behind it in one place, isn't it?
He said that the sewer easement or 200 feet, whichever's greater, they would get rid of it.
They're the same thing.
Would that be okay?
Because the force main there, you can't build no closer than that anyway,
Exactly.
so. I'm just saying that just makes it a good line.
I think he's talking about whichever's greater. 200 feet or
If they build from the stream, that is terrible.
Rob, could you go with just the easement line? Is the consensus of the crew?
The 200-foot line?
No, the easement line, the sewer easement line.
Well, then, because a lot of times it jumps in front of the creek.
Oh, you're
From what
talking
I
about
see,
200 foot?
sometimes it's on the other side of the creek.
I thought it was all on this side.
No, you look up in that corner up there.
Very top left-hand corner.
It's actually
Oh,
in
I
front
see.
of the creek.
Well, yeah, except for that corner. Yeah.
So that's why I was
In other words,
saying,
we're talking about staying always on the far side of the creek, and then another strip.
well, the
beyond
200-foot
that.
line is not even on this side of the creek.
It's just that a straight line, to me, doesn't.
If
makes
you
much
wanted to
sense.
do a
It's kinda
straight
following the
line,
creek.
Straight
that's
line.
south of the creek or southwest, I guess you'd say. You'd have to go about 225, and it'd clear everything, the sanitary force as well as the stream, about 225. But we didn't want nickel and dime you to death.
Is that
250
okay?
right there.
Yeah, that will be okay, that'll be acceptable.
The 225 line? Does everybody get that?
Let's do 225.
Matt, you okay with that one?
And just to reiterate, as I said much earlier, we are planning to have notes on the plat to be recorded, and we'll work all those out with staff that do have certain restrictions and things. So, in addition to the A ones, but that's essentially the main one. Now that we've kind of worked it out, I think, is to explain how that setback works.
Ready for a motion?
And do we got any more discussion? If not, I think we're ready to make this motion. Matt, you got anything else?
I mean, whenever we get to making the motion, we should just make sure if any of the conditions need to be amended.
We wasn't even gonna look at your conditions. We're gonna make our own. That's the way it sounds.
Fair enough.
Well, you had a condition 7 on there. Joe, you want to bring that condition back up on the screen, or?
What, was the applicant okay with all the conditions, Brent? Rita?
Yeah, once we've talked through we've already
Okay.
talked through all the issues.
Okay, so we can change condition 1,
And that goes to the 225.
goes to
right?
the 225, right?
Yeah.
That's what we agreed on.
And then,
So I'll make a
does that
motion.
need to be in the conditions?
I would say also,
I don't have
Also-
that many conditions, Matt.
sorry.
got seven.
Well, no, I was just gonna say, you may consider, I don't know if you want it to remain as a tree preservation easement. I mean, if we move it to 225, it's not really gonna be protecting any tree, so I would say as part of number 1, remove the part about, also including the notes from page 1, or from page 2 on the staff report.
Okay, remove that one.
Yeah, I mean, the 225 line isn't
remove,
gonna,
condition
isn't
number
gonna
1.
act as a tree
In other words, put a-
preservation easement,
Put a
so,
period after 25 and then including on striking.
yeah. Yeah, strike the part after,
Oh,
yeah,
scratch it out.
after the 225.
And condition 8 would probably be with the condition of the applicant changing from R1 and B1 to all A1, correct?
Yes.
To all of A1 for all 4 parcels.
Zone change.
Zone
Applying for a
change,
zone change
to apply for zone change
to A1.
to A1 for
For-
all the property, 88 acres. So I'll make a motion to approve with the setback being 225 feet. And condition number 8 being that the applicant apply for a zone change of A1 of all the properties, track A, 4A, 4B, 4C, and 4D. And I think that's it.
We have a motion by Mr. Solsky,
A second.
and we'll have a second by Ms. Mizell. All those in favor say aye. Those opposed? Motion is approved.
Come on, Jamie.
You got a long way to go, big boy.
Move Jamie to the end.
Yeah, Jamie just found his way to the end of the list.
No break, we wanna move forward.
Now, let's go. I got a phone.
Here.
It makes me wonder if we need to put something in our zoning ordinance
Yes.
about
Down zoning,
down zoning.
waive the fees for down zoning.
Is the Lifestyles Communities next?
Yeah,
Okay.
all right.
Next application be PDP 2017-52, Lifestyles Communities Meals Apartments amended.
All right, this next project is an amended final development plan for Lifestyles Communities, which is the Mills apartment on Magnolia Drive. The request is to amend the existing development to add 32 parking spaces. The Mill Apartments was rezoned in 2009. The preliminary development plan was approved in 2010, the project was constructed in 11 and 12. It includes 228 apartment units, a mixture of 1-bedroom, 2-bedroom, and 3-bedroom units. I think it was originally approved with 454 parking spaces, but that I don't think that number. I got that from the staff report. I don't think it included these garages, so there's numerous garages, also single-car garages on the site. The applicant is now coming and asking for an amendment to add 32 parking spaces around this internal park area that surrounds a sinkhole that was mitigated when they built the apartments. They did some work around the sinkhole, but they left it as open space, but they added parking around it and a drive aisle, a two-way drive aisle around it. Over time, and also as part of that approval, typically we require any apartments over 200 units to have 2 entry points. They had put their main entrance on Magnolia. They asked for the old Oxford Drive entrance to be closed off and be emergency access only. So they put bollards up that were with a key that the fire department could get through that entrance in an emergency. I think over time, this project's pretty densely built, and I think a lot of the garages probably are used for storage, not for parking. There was some parking in the early stages in this emergency access. That was, we kind of cleaned that up with the help of the fire department. It was striped, and that area's been monitored to make sure nobody parks there. But over time, the owners realized that they could use some more parking, so they've initiated this application to add these 32 spots. One of the conditions with the original approval is that this second entrance be evaluated after 5 years, and that 5-year point has passed. So as part of this review, we're also looking at that second entrance. Talking to the fire department and the city, they're okay with the bollards still being left in place at this point. The city is looking at maybe widening Old Oxford in the near future. So when that is widened, we may want to consider opening up the second entrance at that point. But right now, it's the one entrance is working for the fire department as long as they have access to the second entrance in an emergency. So the additional parking spaces will meet and exceed what the parking would be required at this site. With the new parking spaces, there will be 517 spaces total, including the garages, I believe. 228 units, 2 units a spot would be 456, I think, would be the two parking spaces per unit. So this would be about 2.5 spaces per unit, roughly, maybe a little less. So we are recommending approval with the only, I guess, addition, and this is addressing the second entrance, is that when Old Oxford is widened, or if the city comes back and asks for that entrance to be opened up, that we evaluate whether turn lanes are needed, and if they are, they should be the responsibility of the applicant to pay for any entrance improvements along that frontage serving that entrance. So we are recommending approval with these 6 conditions. Number 3 is that the secondary entrance to Old Oxford remain an emergency entrance, and if the bollards are removed in the future, or if the city asks for that entrance to be opened, the applicant shall be responsible for any improvements to that entrance.
Anyone have any
That's
questions
all
for
I
Joe?
have.
Thanks, Joe.
Okay.
The applicant, here to speak.
Mr. Chairman, members of the Planning Commission, I'm Fred Eastridge with ECSI. The Lifestyle Communities did want us to try to get as much parking as they can. Apparently, the fire department has requested that they try to keep the lanes open and clear, so they want to build the 32 parking spaces. And there's not much to the plan, is what it is. And the entrances and everything was discussed at the time of the original zoning and development plan, so we're in conformance with that. And we've asked for the plan to be approved subject to the conditions, and we're in agreement. Not much to say about it.
Anyone have any questions for Mr. Eastridge? Thanks, sir.
Thank you.
We had one gentleman had a question. Yes, sir.
Yes, my name is Jay Griffin. I live on Old Oxford Road, directly across from the Mill Apartments. I spoke to Mr. Kane when we got the notice regarding the parking spaces. Of course, now hearing about the emergency entrance, that is completely news to me. I did not know there would be any consideration for opening that up. But I spoke to Mr. Kane, and there's been some concerns with myself as whether the other residents that live along Old Oxford Road that face the Mill Apartments. Billy Wise is building a 4,000 square custom foot home. And the lot next to me, he was unable to attend for a child at a ball game, but he did give me verbal authority that he agrees with my concerns, as well as Sarah and Kyle Endicott, who live at Tom Price's old property, directly across from the emergency entrance. So basically, I'm not necessarily opposed as much to the additional parking. I do have opposition, of course, because of the safety and the speeding on Old Oxford Road for the emergency entrance. But I spoke to Mr. Kane about some other concerns that we've had, and he thought since this was a public hearing, a representative of Lifestyle Communities would be here. Maybe you could hear our concerns with your permission, and possibly even make some conditions to clean up the act over there at the Mill Apartments as part of this approval process, if that's okay with you. As some of you know, I don't know who was all on the Planning Commission back in 09 and 10. I know Mr. Kane is very well aware of this. This was a very long rezoning process. It went against the comprehensive plan. At first, it was denied by the Planning Commission. It went to the city. Of course, they went along with the Planning Commission's meeting or decision. Within 6 months or so, of course, the economy crashed. We had a global recession and everything helped. So they Lifestyle Communities reapplied to have the city send it back to the Planning Commission for reconsidering based on the economic impact it would have to the area. They said it would bring a lot of local construction jobs, be good for the economy because it was very hurting. Even though we were very lucky in Scott County, it did not affect us because of the growth of Toyota and everything else that it did a lot of other areas in the country. But during that rezoning process, a lot of promises were made that were not kept. A few that there's really nothing to do about now, but I'd like to give you a brief history of it. One concerns the local jobs. Tom Price, who used to live directly across from the emergency entrance, him and myself went through when they were building the apartments, and we'd say over 90% of the personal vehicles of the construction workers there were Ohio license plate tags. So that promise obviously wasn't kept, but that's in the past. Nothing can be done about that now. They promised to be very environmental friendly. They applied to put a temporary rock quarry there because they had to do some blasting. And they were going to grind up the rock into gravel and use that for materials of construction. They promised to keep the dust down so it wouldn't affect everything. Well, I came home and I started to notice all this fine dust everywhere in my house and on my cars and on my boat. And one day I came home for lunch and there was a whole cloud of dust. The wind generally flows that direction to my house. In that direction, that's the natural way that the jet stream goes. And I couldn't even see it in my own house because of all the dust. Well, we've got environmental concern in, and either the water that keeps the dust down had broken down, or they just weren't using it to save money, I don't know, but that was eventually corrected. And then one day, I was sitting on my front porch after work, and I noticed a construction worker with a front-end loader bringing loads of tires and putting them into a big, deep, empty hole that they had just dug within about 200 feet of my front of my door. And, I went over and asked the construction worker what he was doing. He said he was burying tires and I said, why? He said his boss told him to. And I was like, well, you can't do that. That's illegal. And so he took the front-end loader back, and he had a pile of dirt getting ready to push over and bury him in there. And I got Jared Holland, who's the waste management working for Judge Lunch, to be involved, and the deputy sheriffs came over, and they removed the tires, and of course they said they were taking them out to begin with, but we had pictures that clearly showed they were buried. So their promise to be environmentally friendly obviously wasn't kept. One of the other things that they said, there was a retention basin facing Old Oxford Road that they agreed. We were concerned because if it was a water retention basin, it would attract mosquito larvae, be a health concern and everything. They agreed to a dry retention basin. But since the retention basin was built, it has constantly been full of 6 inches, a foot, shallow, stagnant water, constantly. I complained to the on-site managers a few times. I got with Mr. Gene Thomas of the Welco Health Department District. He was very supportive. He provided me with some wafers, I believe they're called, that kill the mosquito larvae. I went to the on-site manager, asked for permission to put those down in the retention basins, and the water runoff from the retention basin runs directly in front of my house. And there's always shallow water in that, and I put those in. And I believe Mr. Thomas had said they had set up a sprayer to spray for mosquitoes, so I think they put that on the city's list of sprays. So that last year was the first year that the mosquitoes had improved, but for the few years before that, you couldn't walk outside in dust for 5 minutes without getting eaten up. There was mosquitoes everywhere. So that did help a little bit. But they also promised to keep the retention basin area free of weeds and, make it look nice, but that is yet to be done. There are weeds 10 feet tall in the retention basins. There are weeds along the back of the property that are grown up to 20 feet tall. They're like weed trees. I have some photographs if you all would
Well,
like.
I think on that line right there, I think you're getting into code enforcement.
Well,
the issues that if you call code enforcement.
Okay, I understand that,
you
sir.
probably get some of that stuff taken care of.
My other concern, another concern about that is trash. One of the promises they made, and of course all this is verifiable, I don't know how long the videos are archived from the city council meetings or the planning commission meetings, but they said this would be a very upscale, nice apartment community. People wouldn't be hanging their laundry out to dry, Section 8. People wouldn't be leaving trash outside. Well, in addition to additional parking spaces, I believe they need additional dumpsters, because right now there's only one trash compactor dumpster in the very back of the property. I don't know if it shows on that picture there, but it's in the very back. And, it's very, I guess, cumbersome for people to take the trash out to that dumpster. So we noticed a few years ago, me and my neighbors, that there was trash bags sitting out in front along Old Oxford Road all the time. Just empty trash bags, not in sealed containers, just empty trash bags. Sometimes we'd see them all tore up, like an animal or somebody got into them. There's trash all strung around, or maybe a rodent or something. And then we contacted the management, and they said because there was only one compactor, citizens or residents there felt that it was too cumbersome to take it all the way to the back of the property to the compactor, so they had a trash service that residents were to leave trash out, and I'm not exactly certain of the hours, but I believe she said something like between 5 and 8 p.m. or 6 and 9 p.m., Sunday through Thursday only, in a sealed container. And that would, of course, keep from having any rodents or any problems like that happening. But they are not enforcing that. People will be leaving bags of trash outside all week long, and they will build up on the weekend to where you will have one unit with 5, 6 empty garbage bags sitting there. And we feel that it not only is a health concern, and Mr. Thomas is going to look into that and contact the property. But yes, sir.
It sounds like everything you're saying is more of a code enforcement type thing. I don't know what that has bearing on this application.
Well, it might not. I agree with you. Maybe I agree with that, sir.
If you're trying to get to a point,
well, the point is like I was saying, I was hoping that if you do agree to the parking spaces, I was wondering, and like I say, I'm not familiar with this as like some of you all are, the processes. maybe you could request, or at least maybe the representative lifestyle community, since you are from Columbus, I'm assuming, not the local, or you're local, maybe you all could clean up the act a little bit, because
Can you
having all
address
these
up here,
trash
please?
bags out here affects
Address up here.
property
We
values.
can't hear you when you
Oh,
turn around.
all these trash bags leaving out there, it attracts rodents. It's aesthetic. It affects property values. We've had visitors come by. They say this place is growing. There's an upscale neighborhood going in behind my house, the Village of Lanes Run. And yet people see these bags of trash laying out all the time. And of course, that is just along Old Oxford Road. This is going on within the entire community. So we think that it's a health concern. And of course, Mr. Thomas said he was, in an email he sent me today, going to contact the management, because there are regulations that trash
Yeah, like I
is
said,
kept
I don't know, Charlie, it might be, I don't think we can put any kind of restriction on
Okay.
this application.
Okay. I just,
Like
Mr.
said,
Kane suggested that
I
it
would
was a
suggest
public
it-
meeting, that I'll bring this up
Yeah.
and bring this up to Lifestyles, that it might be acceptable to you
I
all
would
to hear.
suggest you call Dusty Carter with the code enforcement and try to.
Well, we
get
have,
something
and
pushing
the
there.
response I got from Mr. Holland was that because it's private property, it's not picked up by the city,
Mm-hmm.
that they have no jurisdiction on the trash. Now, they do have some jurisdiction on the weeds and the retention basin, but the Wellco department, the health department says they do have some say as far as the health concerns with, the trash bags being sitting out there and everything. And, and they were going to look into it too. But like I say, I was just here to bring it to your attention because there was lots of problems that's made, the tires buried, the rock quarry. They made a lot of promises that were not kept, and a lot of those are in the past. There's 2 more that could be corrected. And then now, of course, I am very opposed to the opening of this emergency entrance. I have neighbors that have had close calls with accidents. That's a very kind of a sharp curve there.
Well, it's not
kind
gonna
of a
be
wide
opened
curve.
unless the road
Unless that,
improvements are
okay,
done.
so that was news to me now. I did not know that would even be
Yeah,
possible.
that'll never be open unless the
Okay.
road improvements are done.
Well, that's all. I thank you very much for your time then, sir. Like I say, I just wanted to bring that, and I hope Mr. Thomas contacts you, and maybe you all could do something about the trash issue and the retention basin.
Thanks,
It
sir.
would make it a lot better. Thank you very much.
Thank you. Does anyone else want to speak? Any more discussion from the commission? Anyone have any questions, comments?
I don't think we can put ourselves in the place of the compliance officer, but I do agree that if people aren't willing to take their trash back to that one area, that they need to come up with a better plan.
The city's ordinance requires garbage not to be out like that, so no, there's code enforcement is where that needs to go.
Yeah, I think so too.
That can cause a big problem.
No more discussion. We'll entertain a motion of some sort.
I'll make a motion to approve this application based on staff's recommendations with the 6 conditions.
We have a motion by Mr. Moran.
I second it.
We have a second by Mr. Cannon. All those in favor say aye.
Aye.
Those opposed? Motion is approved. Let's see, I think the next one we push to the bottom and
think
think
we
we can wait a
did.
little bit longer. Next item of business is PDP 2017-53, Top Gun Auto Sales. Matt?
Thank you. The project site in this application is just under 1 acre in size. It's located at 1247 Paris Pike. And the applicant is seeking to construct an auto sales facility at on this site. Their plan includes a 1,900 square foot office and around 876, 880 square foot service bay. They're not proposing any type of oil change or really mechanic service at this site. The service bay would, my understanding is the service bay would be used only for washing and detailing cars. The property is zoned B2 highway commercial. That is an appropriate use in that zoning district. The proposal is under the maximum building coverage that zoning district allows. There's no problems with the building height, the required parking. It has water and sewer availability, and as I mentioned before, the access is off of Paris Pike. There are two waivers that the applicant is requesting, and we can get into that here in a minute. Just looking at the project site, I've outlined it here in red. You've got Paris Pike here. And the project site, and we can see this better in a minute, has two entrances off of Paris Pike. And it's sort of located here between the Kmart, or the former Kmart, and the Arby's property. This is the applicant's proposal for the project site. As you can see, here are the two existing entrances to the project site, and there is a large amount of this is currently paved. The site previously was a restaurant, which went out of business and has since been torn down. And the applicant has shown the appropriate parking here. This is the service bay that they're proposing back in this part, and then this front part would be the office building. And so as they are showing, the parking areas that will be used for their merchandise. One other, I guess, item of note for this property, this line right here roughly is where the 100-year floodplain comes across the property right now. So all of this area down here is now within the 100-year floodplain as of December 2017. So actually, I think I have slides on it. There were a couple of issues where they were requesting variances. One being sidewalks, and I know we talked about this some at workshop. I wanted to include this photograph showing the right of way, and as you can see from the photograph and from our discussions the other day, the subdivision regulations do require that sidewalks be put in, as property such as this is redeveloped. I think it is appropriate to allow a waiver to that requirement in this area. If you notice, the right of way isn't actually all that wide. It's hard to see from this photo. Some of the grass is a little bit overgrown and the ditch isn't very deep, but there is somewhat of a drainage ditch there to handle some of the stormwater from the road. And in addition to that, there are utility poles and the light pole for the street that extend in that area. It would be difficult to put sidewalks in there, and I think it would be reasonable to waive that requirement from the subregs. As far as the landscaping, I know this was probably most of our discussion at workshop was centered on this issue. And I guess sort of since workshop, Joe actually pointed out to me that I had actually overlooked a part of the landscaping ordinance. That does allow the applicant to not only count preserved trees for a bonus to their canopy requirement, but it also does allow them to count those trees as long as they meet a certain size requirement towards meeting the requirements as far as perimeter landscaping for both the site as a whole and as well the VUA. So I wasn't actually able to go out to the project site today to verify it, but the applicant, I believe, is proposing to preserve 7 trees. And if those trees are at least a 6-inch caliper, for each tree that is at least a 6-inch caliper can be used basically or counted towards 2 trees that would meet other requirements. So even if some of those trees aren't, don't meet that 6-inch caliper requirement, I think there are sufficient trees that do meet that requirement, and I can verify that before the final development plan to meet the requirement for the trees that the applicant is looking to omit. So as far as perimeter trees along the front of the property here, they would not need to necessarily provide trees. I mean, obviously they could if they wanted to. And these 4 trees that we talked about at workshop wouldn't need to be provided necessarily either. Obviously the caveat being that if those trees don't meet those caliper requirements, but I don't see that there would be enough of them that wouldn't to not cover that. So the only issue actually or I guess 2 sort of issues with the landscaping then would be that the applicant would still need to provide the 18-inch shrub or hedge or whatever they decide to go with to meet that requirement from the ordinance, both here along this property boundary, to screen it from this private road, as well as in this area here. I don't recall the applicant objecting to that at the workshop, but that's certainly something that they could discuss after I'm finished. And then the only other landscaping issue that arises then is that if the applicant does omit these 4 large trees that they were proposing, they then actually wouldn't meet the canopy requirements. They would actually fall, 3,000 square foot short of that. So if you were, looking to sort of, grant them a waiver to the landscaping as part of this development, it would be to the canopy rather than to the perimeter landscaping. And once again, I think if you wanted to grant that waiver, you would be somewhat justified, just given that we do like to place an emphasis on preserving existing trees where we can, and so with the preservation of these 7 trees down here along the southwest corner of the property, I think that's something that we would like to promote and encourage. I did mention in the staff report, and I have left it off of the list of variances on this slide, as well as the conditions that I gave to Charlie. We had some discussion about the oil water separator. I do think that's probably an issue that's best left to Georgetown Municipal Water. If they are willing to waive that for the applicant, then that's probably. I guess Ben might be able to answer that better. But then that's probably fine. But I don't think that they would waive that, even if we waived the requirement on our end. So I am recommending approval of this application. Some of the conditions that stand out, first being that the applicant would have to comply with all the requirements of the floodplain management ordinance. The applicant would need to comply with all of our stormwater requirements in the new Georgetown stormwater manual. I guess condition 6 here is one, as we mentioned before, is one that we're including on all of our development plans and subdivision plats, just to make applicants aware that preliminary approval of any application does have a 2-year sunset on it. And that's all that I have.
Anyone have questions for Matt? Sounds good, Matt.
All right.
The applicant want to speak?
Jamie Tackett, the applicant. Just a couple of questions, just to make sure everything looks good. Go back to the front of the building. I didn't really understand what you said as far as did you say I would need to put some shrubberies up front or something like that?
Yeah, along this, basically here, and technically in the grass area here and here.
Because we got a good standing. The trees, there's probably 20 trees if you're counting 6-inch trees. I was just counting mature trees, but there's a ton of them.
6-inch caliper.
Okay, yeah, but the only problem the issue I have is anything blocking the view of a car. I'm in business to sell cars, not trees.
Yeah.
So what this does for me is it blocks the view. I don't, whether this tall stuff, they get bushy. That's what I'm asking for. Is anything out front? If you look down the side of the right side, there's those big hedges, if you've been by there, that block Kmart to me, makes me private. Those are all staying. They wrap all the way around into mature trees. Then they come up on the other side of the mature trees where we're counting. And in the workshop, we talked about taking those 4 trees out, which was a big help. We talked about the water separator. I don't see any issue as far as asking the water company. I'm okay with spending the money and putting that in. Because I really want drains anyway. So, if I have to do that, that's not an issue. So I don't feel like I need to argue that any at all. So I'm fine with that, Matt. We talked about that the other day. But anything out front that will block the views of me selling my merchandise is one big issue I would have. with that. So I'd ask for variance as far as any shrubberies that connect 460 or Paris Road, Paris Pike, whatever you would say, anything out that way. There's some grassy area that has a ditch run through there, which will stay grass.
Would you be okay with putting them down the side where we're gonna take those trees out? Down, heading back toward the trailer park? Oh, good job, Matt.
Sorry, you need to go along this side.
Shrubs right there. I don't
consistent
think you need
grass.
them in the front, Jamie, and this is the reason why.
Yeah.
With that drainage the way it is,
Yeah,
I think
it's a pretty
anything you
narrow
plant out there is gonna die.
Yeah.
Because of salt trucks and
Yeah.
stuff, it's gonna kill everything.
You know, to me, I don't want any trees at all, you know, but anything that can block, like we talked about, anything that will block the view coming from the left, because I'm already going to be blocked from those shrubs coming down the hill. You won't be able to see my lot until you get in front of it. But I've got good access view with those 4 trees coming out like we talked. That was a huge help.
Yeah.
If I plant anything there, they're going to still block up to the back of my car. And anybody coming, I think what we discussed, anybody coming through Arby's drive-through can see our stuff there. And because I get up a little bit higher.
Yeah.
I start coming up that road. So, I mean, a 2-foot shrub is going to be 4 feet higher than that drive-through if you look at it that way. That's my only concern. But I think once everything, the canopy and the trees, if you've been by there, because I've cleaned all that up and left the mature trees hoping that would help.
Yeah.
I mean, those trees have been there the whole time.
I think whatever you do is gonna be a great improvement on that property, no matter what.
I mean,
It's just- you've already made it look better.
It's going to bring a
than
bunch
what's
of
looked like in years.
tax money to the city too. I mean, $20,000 a month probably.
Well, I think if you consider what Mr. Tackett's done to his current property, it looks nice, it's kept up well. You know, people pass by, but your front always looks clean. Not expected of this too, so.
And like Stephen was talking about the sidewalk, the state issues on that, and I appreciate that. But if it ever comes down through there, I'll be the first to build it. I'll connect it up for nothing. I mean, I would. I wouldn't argue that a bit. So if I could just not have anything out front, I'm happy with everything else as far as the water separator and stuff.
But you don't want them coming down the side either, James.
No, I would love what Matt proposed right there. Would be awesome.
And back there would still be some,
There's really not as much room as it looks like that up there. I think it's on closer more than that looks on that picture. I think
What is?
To the road.
where the blue line comes down on the left. I think you can go up about 4 more cars, and there's trees on up there a little bit further out. Existing
Well, I was thinking
trees.
You got existing trees to push.
Yeah,
over
they're
a little more.
already up in there, so we're doing away with those 4 right there. But really, it goes up a little bit further, I think, of natural trees,
Yeah. that's
which
all.
is going to, yeah,
Mature trees that's already been there for a while.
yes. And I got a telephone pole there already, and some other things that are distracting too. So I just think it would really look a lot neater if it just is kept that way. So that's all I got. You got anything?
Baron Gibson, architect. And just to iterate on what Jamie was talking about, as far as the sidewalk goes, Matt was kind of giving you the rundown on that, but basically it would be the only strip of sidewalk on Paris Road, and it's kind of a narrow spot to build as well. And as far as the trees go, what Jamie was saying was, these trees and shrubs out front and on the side would be what we'd be looking to get a variance on. So that's pretty much it.
You have something there?
still willing to put the trees in the back corner here? Or you'd rather not?
Those are existing trees in the back corner.
There's 2 proposals.
There are a couple proposed here.
Oh, on the
Yeah, I think this one and this one, I don't know that there was any proposal to remove those.
They're all existing.
Yeah, there's a bunch of existing trees.
Those are existing.
No, those are proposed, but we were gonna
Right.
waive that. That was
Right.
part of the
Yeah.
waiver.
Proposed trees are what
There's
we're.
enough because those were not included in the 7. So those were the ones we weren't gonna require. You put in the 4 on the left, plus I think there's 2 or 3 on the back end.
The,
Here on the corner.
Yeah, one on the corner back, one on each rear corner, and then the one on the, next to the building itself. We weren't gonna require those, I thought.
I don't know that we discussed that. I thought the discussion for
Well,
not
we did.
requiring additional trees was just this And
Yeah,
well,
that's-
these,
that's what I was
these
thinking.
four and then any along the front.
Yeah, we
Well-
didn't really want to plant it. I mean, none, no trees, just existing is what we were talking about the other day.
And part of our argument for that is that of the 7 trees, the zoning ordinance requires 22% square footage of your site be canopy coverage. Of those 7 trees, they're large trees, they cover well over half of that requirement. So there is a good bit of the canopy coverage already required. So we're already in, probably in excess, well in excess of what's shown there.
But I still think you were short based on his,
Yeah.
you were short 3,000
If
square foot.
additional trees are planted, I mean, you'd still only be covering 10% instead of the 22.
Right.
Which is due, which we talked about the other day as far as seeing the cars, birds flying over the cars, sap, leaves. I mean, as far as for automobile, kind of like the tractor place, John Deere, any car lot, Frank Ship, you're not going to see big trees or anything around them. So I think that's what we talked about in the workshop. That's how we come up with it. Any questions?
Yes, sir, Mr. Tracy.
Kenneth Tracy, business owner beside it. All I'd like to see is elevation numbers on this. There's no elevation numbers showing about where it's going to be when it's done.
Ben, do you have elevation numbers on this?
Yeah, it's in the floodplain.
To build at grade, no fill.
Can we put that in the drawing?
Well, this is just a preliminary, I guess it would be in the final.
It would be in the final.
Final plan.
Will that come back before y'all? The final plan?
What about it?
Come back before you?
Probably
Make sure that
not.
we
It'd
see
probably
it.
go to staff.
Is your concern that they might raise the site or something?
My concern is what Eastridge and Thoroughbred turned in, the cross-section data for 1205 went all the way over to this property. And it was already messed up. So did the state do it right with this? I noticed when Ben signed his application, it was for acknowledgement only for the flood permit.
Like I said, I think the final development plan would have all the numbers on it. We don't have.
I just
it
didn't
right
want to
now.
wait till we got done and it was already signed off on to see these numbers.
I didn't hear you there. What'd you say?
I didn't want to wait till the end and it was already signed off on to see the numbers.
Well, it won't get signed off on it until staff reviews the numbers.
But I just wanted to make sure I seen it.
Huh?
I just wanted to make sure I seen it, the numbers.
Well, you can go down to the office and see them at any time, I guess, as soon as it's turned in, You can ask when
You know when they'll have them on there?
Well, whenever the staff gets the application back,
Are they able to contact me and let me know?
Well, you can ask them and see. I'm sure they would. I don't see no reason why they wouldn't. Any more discussion? Does anybody else have any other questions?
It was kind of nodding of heads there with someone say, yes, we will contact him.
Yes, if you want us to contact.
Yeah,
them, we
staff,
can
if you,
instruction.
yeah,
Make it definite.
yeah. We'll make sure staff contacts
Yeah.
so you can see it.
Jamie, if you're gonna put all these trees out, make sure you plant some flowers or something, all right? Make this place look good.
And we've given on every point. You need to do your part there.
Well, I better be there for the grand opening and see it.
Giving away a free car?
Free coffee.
One free car?
Free coffee. Yeah, I got a few I'd probably give away. Take some hammers to them.
Anybody else have any other comments on it?
I'll make a motion to approve waiving the variance of the sidewalk, waiving the variance of the planting of new trees, but striking from the application waiver of the oil and water separators. Mr. Tackett agreed he'll put it in. And there was a condition on there, I think, that we had to strike, didn't we? And also the bushes on the front and the side. Will give you a lot of visibility there to sell a lot of cars. And so that's my motion.
I second it.
I have a second, have a motion by Mr. Solsky, I have a second by Mr. Cannon.
Correct.
All those in favor say aye.
Aye.
Those opposed? Motion's approved. Y'all have to sign some paper.
Thanks, Matt.
One more to go.
He stopped me in the middle of the road. I got lost from the speed. I chased him out. I started saying, well, this doesn't have anything to do with us, what he's.
I drove over there. Let's get there. Who's got the next one, Joe? This place across the street. Our next application is ZMA 2017-54 Windermere Apartments Phase 3. It is a rezoning request, so that is a public hearing. So we will open the public hearing. Matt.
All right. Yes, as you mentioned, this is a zone change hearing. Just a piece of housekeeping before we really get into it. I've I don't know who it was. I think it was the owner of the adjacent apartment complex contacted us. And they did not wish this application to be called Windermere Apartments Phase 3. So I informed the applicant, and they have since changed the name to the Crossings at Windermere. So if you see that throughout the PowerPoint, that's what the applicant wishes this development to be named as. What the applicant is proposing is to rezone 6.039 acres from B2 highway commercial to R3 high density residential. This rezoning is part of a larger I think I have it on here, 7.905 acre site that is currently entirely zoned B2. The applicant is proposing to let a portion of it remain zoned highway commercial for commercial use, as we'll see on the concept plan. The property has access currently from Paris Pike. There's also proposed accesses from Windermere Path and Caroline Path. And there are 3 variances that the applicant is requesting as part of this application. So this red line here outlines the project site. This is Paris Pike and I-75 here. These are the previous phases of Windermere Apartments down in this area. They were all rezoned at the same time. And the applicant's proposed entrance will line up here across from Falmouth Drive, part of Rocky Creek. So as you can see, the surrounding zones, B2 here to the south and the east. To the west, we also have B2. This is actually a B4 zoning to the north. And then this is an aerial photo of the project site, just so we can get an idea of the development that's out there currently. As I mentioned, there is an existing apartment complex here that it will eventually connect to, and then the Rocky Creek development to the north. And there is sort of a buffered area here between them and the next development to the west. So this, I just wanted to give you an idea of what areas the applicant is looking to rezone. So I've sort of hatched out these areas that they intend to remain commercial. And so the remainder of this site is really what they're looking to rezone to high density residential. I kind of go over it in my staff report, but in the past, the previous phases were allowed to develop as high density residential, even though they were zone B2. It was thought that a conditional use permit in the B2 would suffice to allow for a residential use. When the applicant approached us about development on this property, we advised them to seek a rezoning because residential is not listed as a conditional use in the B2 zoning, and so a residential zoning would offer a more permanent solution to any issues that might arise later with a residential use of the property. So, as we've seen before with zone change applications, there are findings that state statute requires that we find in order to recommend a zone change onto the legislative body. So the first thing that we would typically look at is whether or not, an application is in compliance with the comprehensive plan. If we can't find that, then we look to subsections A and B. I won't really go into subsections A and B at this time because our finding is that this application is in compliance with the comprehensive plan. Our comprehensive plan that you all adopted last month designates certain areas as neighborhood centers, and as part of the description in that, those areas are intended to be mixed-use areas. Those areas are intended to be connected. The residential and the commercial areas are intended to be connected through multiple modes of transportation. In this case, the applicant is proposing connections, both vehicle and pedestrian, to the commercial areas in their development. And lastly, these neighborhood centers are intended to sort of be the areas that are appropriate for a high-density residential development to support those nearby commercial areas. So, we find that, staff finds that the application does meet not the conditions, but it does satisfy the comprehensive plan, and so we don't need to consider subsections A and B. When we look at the concept plan for the development, I've indicated here the access points that the applicant is proposing. When we look at the commercial sites do look to be reasonable. I don't really have any issues with the commercial sites. There's not really any issue with the density that the applicant is showing with the concept plan either. And really, I guess we can just kind of talk about, for the most part, the three variances that are being requested. The first, and maybe the sort of the trickiest to describe, but is the setbacks. If you'll notice, this dotted line that runs along here is the setback line for this zoning district and for this proposed development. It's a 25-foot setback for the rear and the sides, and as you can see, some of these proposed buildings come over that line, and the applicant is asking that you look to reduce the side and rear yard setbacks from 25 to 15 feet. What I'm proposing is a little bit different from that, and I'm proposing that for these areas that what I'm considering to be internal to the apartment development overall between this property and the previous phases, that we do grant that variance to reduce the setback from 25 to 15 feet. So that would apply really for any buildings along these lines that would be internal. I'm proposing that for anything, any of the other property boundaries, so these boundaries in particular that are between the proposed high-density residential and the commercial areas, or even should the concept plan shift when they bring in the preliminary development plan, this property line over here, I'm proposing that instead of just granting a blanket reduction in the setback, that we instead allow the applicant to average their setback. So if we look at this building here as an example, it's really just this tiny corner that crosses the setback line, and the majority of this building is actually set back, sort of at an angle and an increasing distance behind that setback line. So that building, for example, would meet that averaging requirement. So rather than allow the entire building to be 15 feet from the property line, we simply average it, and most of the building then would result in being further away. And the applicant is also proposing to provide additional screening where that occurs, just to sort of mitigate any problems that might arise. And the other variance that the applicant is requesting with this application is related to the parking. The previous phases of the apartment complex were allowed to do 2 parking spaces per dwelling unit, and the applicant is looking to continue the same by requesting that we reduce the parking requirement for the 2 and 3 bedroom units. Currently, that parking requirement is 2.5 parking spaces per unit. They're looking to reduce that down to 2.25 spaces per unit. So when you combine that with the 1.5 spaces per unit required for the 1-bedroom units, it all averages out to 2 parking spaces per unit. So I am supportive of that variance request as well. I know there was some discussion at the workshop about whether it's more appropriate to approve those variances now, or approve them, or I guess sort of consider them later with the preliminary development plan. I think as far as the parking, I think it's pretty reasonable to look and approve that now, because it's not quite as site specific. If you wanted to wait on approving the setback variances till later, I think that would be reasonable. But I think also the sort of the compromise that I've struck with the way I've worded the variances, I think that it would be appropriate if you wanted to approve them with this with the zone change. I think that would be acceptable as well. I am recommending approval of the zone change request with those 3 variances that I outlined, and the 2 conditions listed here. Those being that they come back for preliminary development plan approval, and then they follow all of the regulations of the zoning ordinance and the subregs. And that's all that I had.
Matt, I got one question for
Yeah.
you on the B2 area up here with the retail, whatever it is.
Yeah.
The numbers for the parking spaces, what were they based on?
I think they were just sort of based on I can't remember now.
I'm just worried. I know this is
You're worried that it might not be enough parking for the commercial
Yeah,
areas?
I hate to see overflow go into the residential part. Does that make sense?
Yeah. I think the applicant could probably answer that, but I can look at it as well.
Okay. I know we'll have to go back over it on the preliminary too.
Yeah.
but We were talking about going ahead and try to do some parking spot,
Yeah,
with this
no, that's
zone change,
true.
so. that's
I
what had
mean,
me a little concerned.
at least as far as I know, the applicant at this time is not looking for any variances to the parking requirements for the B2 area. A lot of that in our zoning, in our subregs, is based on the specific use or the specific commercial use of a property. So, you would have a different, for example, there's a difference in our parking requirements even, between, a restaurant and a retail
I just know if we
store.
had a Red Lobster come in there, it's gonna be hard to get enough parking.
Yes,
You know what
yeah,
I
we
mean?
would certainly want to keep an eye
So,
on the parking for
just
those.
saying.
Matt, I have one other question.
Yeah.
Get it.
If we go strictly by that average, you don't think we need to at least maintain a minimum, at no point be closer than 15 feet? If you go with an average, if you're not careful, it could be
that's
0 on one end and 50 feet on the other.
that's a good point.
I don't want anything that close.
Yeah.
I think you need to keep a minimum.
I think that's a good point, and we could certainly set some sort of minimum
I'd put a
add that
minimum
into the
15, and
variance.
if they meet the 25-foot average, then that's, otherwise.
Would you prefer to wait for the variances and stuff on a preliminary development plan, just do the zone change?
Well, I'd almost,
Yeah,
I
'cause
don't
this
know what
isn't gonna
steps.
bind all of that. That really is a development plan matter. This is just to know it now, just as they go forward, but that is actually the preliminary development plan stage.
Does anybody else have any questions for Matt?
We're being asked to rezone the two
Yeah.
squares up there.
Yeah,
That's the bottom
you're
part around.
rezoning everything but this parcel, or this future parcel and this future parcel.
So there's 10 buildings in of the high density. How many people approximately would be living in those 10 residents?
I can do some quick math. They're proposing 96 units. I think for Georgetown presently, there's about 2.57 people per dwelling unit, so you'd be looking at around 247.
How much?
About around 247 people.
247.
How many units was it, Matt?
It was 96 units, I believe. Is that correct? Yeah. 164 beds.
Any more questions for Matt? The applicant, ready to speak?
Nick Briglasco, Barnum for Talbot Roberts, here on behalf of the applicant. I have a quick PowerPoint that I'll just reference more to answer questions and to address that. We've already seen a PowerPoint here. I have printouts as well, so I can go ahead and just so you have a copy, if you don't mind.
Instead of the arrows, the page down, we'll go to the next one and the page up. And then the one button is the page down.
Is this a full screen? Again, it's Nick Briglasco here on behalf of the applicant. This is in essence, this is the third phase of the Windermere Apartments. It is the original approval was in 2001. The second phase was 2006. Those have been, successful. This is, it will be obviously not part of that. It'll be a standalone apartment project. So that's why the name change, as it was referenced here. But it is, again, just a request for a change from B2 to R3 for a portion of the property. And I can go through and answer some of the questions that were raised earlier discussion, as well as Brad Boaz is here as well from CMW, who can answer, for example, the question on the parking, maybe a little more detail as well. We saw this earlier. This is, again, just the zoning map showing where the property is in relation to Paris Pike there. Again, it's just another aerial photograph to show its relation to just to the, I guess, the south there is the existing apartments. Then there's a Ball Homes development across Paris Pike there to the northeast as well. But just for relation of it all, this is the current development plan. This is just a colored up site version of it. The two outlots on the front there remaining commercial. The request is to keep those commercial. The one on the left being for, at least now, proposed for a restaurant. It shows a drive-in, so it would be some form of fast food or a restaurant that would have a drive-in with it. And then the second one, which would be to the east there, is shown as a retail facility. They're not tenants right now, so we don't know if it's a Red Lobster or what it could be at the end of the day. But those two would remain as is. This does have a separate, shown as kind of in the center, a clubhouse and a pool, because this will be, again, a standalone apartment project, so they have its own clubhouse and pool as well. It will provide the pedestrian connections and the vehicular connections to the other project, but this would be separate and distinct with regard to that. One of the items that was mentioned related to the variances, and I don't have a pointer here, but the ones that are...
Give a pointer, it's on the remote.
Show him the point.
Oh, okay, sorry. Yeah. These, as was mentioned, the setback here, one thing I wanted to point out is the existing apartments, those buildings actually would encroach as well. They are built right up to the line. I think this one actually, technically, this building was even built over the property line, not only up to the property line, but actually technically encroaches, which they're addressing now as well with this to help fix that issue. But because these are, that variance request there for the setback is truly internal, it's between these apartments and the other ones, we think that really fits and works well because it's not much different than you would see between the other apartment buildings in the existing phase 1 and phase 2 of the Windermere. As far as the request or the mention with regard to the, there's a suggestion of taking an average of the setback there, and that works fine, works great for us. The point was very well made, and technically if you have an average, you could put a building on a catty corner where it's 0 and 50 and you still hit the same.
25.
So we understand. So we could, if you wanted to just put the minimum of 15 as we've shown here, as is being proposed. I think the only, as far as whether we address that later or with the plan or we do it now, I think the idea was we want to at least have an indication now because that could change how we lay out the plan. If we know that, for example, that would work and we have a 15-foot minimum there and then an average, we would know where that building would go, where we could put it and make it work. And that way we can comply with that, whatever requirements there are with regard to it. And then, again, just shows another one with all the details here. I have some pictures of the site. I'm sure everyone here is very familiar with it. It does sit up a little higher off of Paris Pike from the road there. I think it should have been used as a dump site for the soil and things of that nature before. There was a traffic impact study that was performed. It is in the packet that I gave you in case you had questions about specific turning movements or times of day, peak hour generation, and morning and evening. But at the end, it does state that this would have a negligible impact on the the traffic in the area. And then we also have the right turn lane that is being shown, which was recommended as well. with it. But again, this is just really is to a request to kind of continue what has been a successful project before with the prior phases and to keep it going. With regard to the parking, I think that was that parking, what's called a waiver or variance with regard to the reduction, that was granted in the prior phases and it worked well. Obviously, this applicant wants to make sure that they can't lease apartments if they don't have enough parking for them. So just basically because it had been successful before and it was sufficient parking before, that was the reason for this request as well. One of the other differences here compared to the prior phases with the apartments, I believe almost all those were 2-bedroom, or virtually all 2-bedroom. This will have 1-bedroom and 3-bedroom. So the idea is to offer a greater mixture. There are people who come to work at the Toyota plant, for example, and they need a 3-bedroom. It's just simply they can't live with a 2-bedroom. So, or alternatively, they may just need a 1-bedroom. So, one of the items that would be different here would be a greater flexibility in unit size as well. And with that, I can take any questions. And again, Brad is here and can. May I have you get up for a quick and just answer? There's a question specifically earlier about the parking for the commercial lots and whether it'd be sufficient, and just let him talk to that to maybe answer more intelligently.
Thank you. Again, my name is Brad Boaz. I'm with CMW Architects in Lexington. And just to answer your question about Lot 1 and Lot 3, so we're exceeding the requirements of those uses right now with the parking for a restaurant and the retail space. So again, there's always a chance they could park where they're not supposed to, but we're exceeding what's required for the 2 commercial lots. And on the 2 variances or 3 variances, if you all feel comfortable with that, it would just help us as we're trying to move on to that next phase of the development grant process. If you could grant those, we have a better feel of what we can work within, and so hopefully that would help expedite the next approval. If we know with those setback reductions and the parking variance, if you feel comfortable with that, again, if it works well for you all now, we would just appreciate you moving forward with that. But if not, we can still tackle that down the road.
On a larger B1 building there, the 6,000 square foot building, are there enough spots there if it were Red Lobster?
Well, then, if it was Red Lobster, I doubt it.
Sorry.
Or Cracker Barrel, yes. My grandfather would be there right now.
What is the most heavy, like, the requirements for parking space on a business?
150, coming for 150 square feet.
So they're about there.
That's what they're showing.
Okay. Okay.
Correct. It's required 30 spaces, and we're providing 41, so we're exceeding by 30% or something.
Good. Does anyone have any questions for the applicant then? We're getting ready to come to that phase.
I do, just the only thing I did the numbers because I like numbers. There's only 4 units that has 3 bedrooms. 60 of them have 2 bedrooms and 32 of them have 1 bedroom. So to me, the 2.25 parking numbers, I think it looks good.
Any more questions for that?
My
All right, ma'am.
concern,
We're
I'm
ready.
concerned with both of these,
well.
these 2 entrances. If you're going west on 460, there's no turn lane for a left turn into either one of these entrances.
If you're going west on 460?
If you're going west, yeah. If you're going east on 460,
Oh, I see what you're saying.
you got left turn lanes going into Rocky Creek, but you got no left turn lanes to come into either one of these.
Yeah.
Which means that if somebody's
Joe, do
trying
we have to
turn-
require widening of the road then? Turn in, turn out?
Well, I think the traffic study recommended a right turn in. It didn't recommend a left turn in.
But if you're coming from Paris and you want to make a left turn,
If you're coming,
Yeah, but
you don't have a turning lane on either of them.
Not much of that
It means
traffic.
you gotta sit there and back traffic up until then they go around you.
Correct. And we talked to District 7 about that, and we've discussed that. And again, with the traffic study in hand that was done independently, they kind of agreed at this time it's not really required. Obviously, I see your all's point, that is helpful. They felt the traffic coming from Paris toward Georgetown wasn't enough to merit that turn.
And just to also reiterate that, it's the very last page of the handout that I had provided, but it does show that the westbound on Paris Pike, taking that left is the level of service A, and then even 2029 with the build, it would still remain a level of service A. So it shows it's a very, very strong A, quite frankly, as far as the level of service. We're pulling up here. That just to kind of just explain why that that didn't come up. It was because of how well that is operating currently.
I see the same problems that you cross the interstate and get over around Wendy's and all these areas. There's constant conflict with people trying to turn right and left there.
Good place to be at lunchtime.
It's a nightmare sometimes.
Ma'am, if you want to come up, state your name.
My name is Angela Shaw, and I represent the management of the current Windermere Apartments. I would, not agree with this. Just as a business owner, you're building apartments right on top of apartments that essentially look the same. So, also it's called Windermere. I mean, we're called Windermere. The Windermere name is used regardless.
I think they made a note of that it would be called Windermere.
I think it was the crossings at Windermere, right?
The
So they're
crossing-
using the
crossing at
Windermere name.
That'd be into something, I don't know, getting over our heads in a legal battle, I would assume. I don't think we have no say-so on what a name can be or not be,
Right. Also, the traffic right now, we have 70% of our tenants work at Toyota. Just trying to make a left out of there, I mean, we're gonna need a light or something. I mean, it's bad.
That'll be up to the District 7 and the applicant. They have to go to District 7. Whatever District 7 says, that's what's gonna happen.
Right, and then also, like, the entrances in the back to Caroline Path, I saw where it just kind of had, you're gonna just make a road connecting that? Like, I mean, how does that happen? If you don't own that property, how can you connect the roads to make that happen? Shouldn't there be like a gate or
Well, we'll let him address
something?
that.
Sure.
Yeah, so obviously we wanted to show the separation since they're two separate property owners, and we do show a gate there to kind of delineate from the new development from the prior development, and that we'd also put the gate there, similar to what we talked about, some other plan was for the emergency access, to have two accesses into the Windermere's 1 and 2, but also just allow a second exit from people living in Windermere's 1 and 2, so that the people that wouldn't have a connection into 1 and 2, but coming out would have a free flow coming out, so that your old tenants could use that to exit onto 460. And those are public access easements. So Ben, correct me if I'm wrong, but those are public access. I'll have time if they touch our property.
I don't know that they're platted right now.
There. Yeah.
Am I able to get a copy of this plan? Like, or do you have an extra copy that you can have? So
Matt,
those
do
are
you
my
know?
concerns. I mean,
Are they even allowed to tie into down here on the bottom and the side over there?
It's private.
I mean, isn't that privately owned?
I mean, I think they are private streets.
Wouldn't
I
there?
don't know what the downside would be.
If they didn't have that connectivity, would they?
I mean, I think it was always
I'm
planned
not
to
sure
be connected to the second entrance. I would say it's probably
the traffic
a great idea. Well, I would say it's a great idea.
Oh, I know, yeah, I think
Since
it's
these
great.
funds only have one way in and one way
Yeah.
out.
That gives us a lot of
But anyway, I'll
connectivity
just
through
get
there.
information.
It actually benefits the existing, it doesn't particularly benefit the new, it benefits the existing.
Public access, but they are not city maintained.
Yeah, they're privately maintained, but they're still public access.
And I think that was part of the thing, because this would have its own pool, clubhouse. The connection is to the existing shown here is just to provide the connectivity. There's no real benefit to this project to that. But it would, the first mention was, all the tenants that are Toyota workers who are leaving, going to work at the same time. Right now, there'd be one exit. This would provide a completely separate exit that would, way to get out of the property in addition. So it would actually really help improve that.
And the one benefit, ma'am, you may not have heard, because I think there were a couple too many conversations going on, is currently there's one entrance in and out, and you have a second one in case fire truck ever need to get back there.
Well, I mean, we as Georgetown, I live in this community, and we have a lot of apartments coming online. I mean, you all know this. And so did we do any type of like surveying to see how well they're doing? I mean, I know Ball's building like over 200. I mean, how do we know that they're able to fill those vacancies? I mean, how do we know this?
Staff did conduct a quick survey there.
What was it, 97% occupancy or something?
And no, it was like 90 to 92 on average.
Which typically average occupancy is 95%.
I don't really think it's up to this commission to decide what somebody should and shouldn't build either.
Well,
Well, it's not, and we've also got, we can't approve everything as a partner, we would be very smart.
And nor do we.
I mean, what are you saying to this current business owner, that you're just gonna allow just apartments to go up everywhere, and that's?
I think this is a great idea. I think that's the perfect thing for this area. This is my opinion.
Ma'am, you have a percentage of your people in your current apartments that work at Toyota. What was, I missed what that was.
About 70%.
70%?
Wow. Yeah.
How
They
much
keep
do
us
you,
alive.
how much do you keep rented out there?
Well, we've dropped, with all of the new construction, you know, Anderson's going on, they're building over 200 and some units. You've got Ball getting ready to, I mean, they're getting ready to occupy, they're getting ready to, I can't believe they're not even here, but they're getting ready to build about 300 units. I mean, that's a lot of units for Georgetown. We're gonna flood the market and potentially lose businesses because of it.
And it's not just Ball either.
I know,
Dennis
there's a ton of
Anderson's
them.
building a bunch of.
Did you
apartments.
say how much y'all have occupied?
Right now, we are sitting at, but we use a system that fluctuates rents called YieldStar. We've had to actually take down our number of how much we're charging at the door, and it's 94% today, but we're going to drop to about 89% at the end of the month. I mean, Toyota's not hiring right now through Kelly Services, and I think that's kind of pushed us back a little bit. But it's something to think about, and that's why I'm here.
I don't think rent dropping is necessarily a bad thing, because that can get some more people in some housing where they can afford, you know? So I
It
don't
is when
necessarily
you're
think
talking about revenue.
Rent dropping is a bad thing. So.
And explaining why the rent is dropping, you know, with different ones coming in. So I'm not for it, and as a resident of Scott County and living right next door to the property, there is a lot of traffic on that road, and something needs to be done about it.
Thank you.
Thank you.
Did you want to say anything? Does anybody else want to speak on this application? We got any more questions for anybody out there? If we don't have any more comments, we're going to close.
Make one comment or
Yes.
question. You have the two entrances there. And it was indicated that the second entrance would be helpful. But if you're coming out this entrance and there's traffic coming along, the second entrance is going to have that same traffic coming along, but it looks like you still got to stop.
Yeah,
And that's
but-
not going to really make a lot of help.
I think the main thing is going to give them a second way in and out of there.
In, I can see, but going out, I don't see it's going to make much difference.
Well, if one entrance blocked, they could all go to the other entrance.
It's not an issue turning right, but it's an issue turning left.
Yeah, that's what I
Either
mean.
one.
Yeah. And the second thing is,
My daughter used to live in Windermere. I used to be in and out there all the time. It's not that big a deal getting in and out
big
there.
a deal.
Did we expand by 38 units? Because we're now 294.
Okay, so it's okay for you guys to expand, but you don't want nobody else to expand. That doesn't make a lot of sense to me at this point in time, so.
That's what I'm saying.
Yeah, any more
my other
comments?
comment was that I don't think it's our responsibility to provide space for anybody that wants to live in Georgetown. I think it's our responsibility to control things to a certain extent. It was said we needed, I think someone said the other day at workshop that there was a need for this, but I think it's more to say there's a want for this, people that want to move to Georgetown. Some of them work at Toyota. It's my understanding that, I'm really surprised at the 70% thing. Because I understood from the staff that most people that live in Georgetown do not work at Toyota. they work elsewhere and just want to live here. But I don't think it's our responsibility to make sure they have that opportunity. We need to control things to a certain extent for the benefit of those who already here. Less traffic, less crime, less taxes, and all that sort of thing. That's my opinion on that issue.
Good comment. Anyone else? Any more comments before we close the public hearing? You'll have to come back up here, please, because she can't hear it on the tape.
Just the fact that the Windermere name is being used, I mean, that in itself is a problem. So,
Okay.
that's where I'm at.
We wouldn't be able to control that, though, would we?
No, we
Take that to court.
that's a legal matter. There's state law on what kind of names you can use, the differences they've got to have, and that's not anything at all we can do to let.
And just to talk to that, first, I mean, obviously our client, someone get into a lawsuit over a name, but that is, you know, a separate legal issue. But, you know, of the last 10 projects that I've worked on, I think 9 of them ended up changing their name somewhere down the road anyway. It's just they have a name to get going through the process with it. So that would be, you know, discussed and revised. And I understand the concerns as far as, you know, is there a demand, but there obviously is still very high occupancy rates, very low vacancy rates at these apartments. And this applicant is not going to spend, will probably be in excess of $10 million, is my guess. I have no idea what it would cost. But, you know, if they weren't sure that they would be successful in this and they could build these and rent them and do so at a rate that would, you know, there was the demand there, you know, but that is really just, again, just a market condition in a way, you know, with that.
Thanks, sir. If there's no more comments, we're going to close the public hearing at this time, and then we'll have discussion amongst the commission and the staff. Does anyone have any more questions for staff, or have any more comments, discussion they want to have on this application? I think we've covered just about everything, really. I think all we'll have to have is a motion at this point in time.
Now, are we voting strictly on the zone change, or are we voting on this?
I think it's up to you how you want to state your zone, how you want to state your motion. I think the applicant
Joe,
has.
would these be, are we voting on both if we want the preliminary development plan and
No, I think you would just be.
on the zone change?
The zone change and the concept plan.
Concept.
Recommending approval on the way.
As far as the details on this thing, that doesn't even matter at this point, because as Ben was saying, a lot of this stuff isn't gonna work the way it's drawn right now anyhow, will it?
Well, it could change. It could change significantly. But, the waivers would be approved, on the concept plan, and you would have to bring the preliminary.
You're voting on the zone change, but if you want to approve the waivers would be approved on the concept plan and carried forward to the preliminary development plan. Yeah, well, the waivers would be recommended for approval, I guess.
And that then gives them guides as to how they come back with their preliminary plan.
But you aren't approving a preliminary development plan.
A concept plan, right? Not
A concept, you are approving a concept plan,
Yeah.
not a preliminary development
Yeah.
plan.
I'm definitely not in favor of reducing the parking. We're gonna run into this problem time and again, especially when you have 2 and 3 bedroom units.
But there's only 4 units that are 3 bedrooms, though, Stephen.
Yeah, I know it is, but don't reduce them.
I did the math.
If there's only 4, then why worry about it? Keep it at 2.5.
They're keeping it consistent with what Windermere has already. They've already stated that, they're keeping it consistent with what's out there already. Like I said, my daughter used to live out there, I never had a problem finding a place for them. I mean, I kind of agree, I think, you know, if we had one application come in and say, we need more parking space,
We
and
need
then we
more
got another
parking.
one say, we don't need as many.
It's hard to add them, but
Kinda,
it's easy for them to sit empty, but it's hard to add them.
especially in a tight spot like that. Anyone want to care to make a motion? I think he's still thinking.
Mr. Chairman, I would, another comment, it's not our place to decide. It's a free economy, free country. If people want to build apartment buildings, as long as we have places where they can go, and we are creating another place for apartment buildings if we rezone this.
Well, that place was already created when we did the comprehensive plan. This is consistent with the plan. And that's just Mr. Weissman's comment. That's when limitations or adjustments and that sort of thing are made. And just like Fayette County finished theirs and decided no more new property. Of course, UK owned most of it, so that had something to do with it, I guess. But that's when that decision is made. Once you've planned the property for a certain type of development, you can't really come back now and say, well, we don't want you there after all. We've done that. We'll review it again, when the next plan review comes up.
But this is currently B2, and it's not R3, right?
Well, but the recommendation is that it is consistent with the plan. And maybe you could make the decision that, no, we need B2. We don't need that. I suppose you could do that and make those findings.
Matt, how many parking spots are there total?
I believe they're showing 192 for the residential portion.
If you had nothing but adults living in here, and each adult had a car, you'd need 220 spots. That's if there's no children, so that's very unlikely. That's double beds, double occupancy,
Well, our current regulations would require them to do 208 parking spaces. Even our current regulations wouldn't require that many parking
That's
spaces.
what I'm saying.
And I think, I'm granted, the decision is ultimately yours whether or not to grant the waiver, but, it is consistent with the previous phase, and, to my knowledge, we've not had any issues with parking
So
concerns
the
at
requirement
the
would be
previous
how many,
phases.
208?
16 different.
Yeah, the current
difference.
requirement would be 208.
Yeah, it's 16.
Versus 192.
So, I'll make a motion. Or do you want to make the motion, or you want me to make a motion? All right, I'll make a motion to approve ZMA 2017-54 rezoning request from B2 highway commercial to R3 residential for the 7.9 acres to allow for multifamily units located on the south side of Paris Pike, east one of I-75 with, I just lost my stuff. There it is right here. With the variances in place as well as the conditions.
We have a motion by Mr. Solsky. Matt, you got something?
Just if I may, the 7.9 acres is their entire site. They're only looking to rezone 6.039 acres.
Sorry, so
But
change that, yeah.
I'll second
And we have a second by Ms. Mizell. This is a zone change, so we do have to do a roll call. Mr. Wiseman,
No.
Mr. Solsky,
Yes.
Mr. Moran,
Yes.
Mr. Cannon,
Yes.
Mr. Caldwell,
Yes.
Mr. Smith,
No, based on the parking.
Ms. Mizell,
Yes.
and the chair votes yes. Motion is approved. Need to sign your papers. Thank you guys for coming.
Thank you.
On their preliminary development plan, they'll have to probably send you notices on that.
It'll go to city council still.
Oh, the zone change have to go to city council, I'm sorry.
So, yeah.
so that I can let the others know.
It'll be, 2 hours.
Well,
You got approved
where
dates.
my wife is.
Went into the parking lot.
Yeah.
Yes.
Like them was She couldn't believe I was here that late, so she came in.
Our next item of business, Matt, you can handle this. Our next item of business is approval of the 2018 Public, or Planning Commission meeting schedule.
Yeah, just to go over briefly, last month we approved the filing deadlines, the planning commissioner workshop, and the planning commission meeting dates. Those are all pretty set in stone. We follow the same schedule every year. We did adjust the dates for the technical review and the corrections deadline, just to give both the applicants and staff a little bit more time as far as turnaround on making the corrections, and then on our end, receiving the corrections and writing staff reports. So the only unusual date in there is probably the February 23rd corrections deadline. That is a Friday rather than a typical Wednesday, and that's just due to February being a short month.
Do we need a motion on this?
I believe so.
Yes.
We did with the other one.
I make the motion that we accept the planning commission application deadlines.
I'll second.
2018.
We have a motion by Mr. Smith, we have a second by Mr. Solsky. All those in favor say aye.
Aye.
Those opposed, motion approved. Is anything else?
You had talked about the Bluegrass RV, and I think Bruce Langford is here. I think as a representative of the applicant, if you wanted to have that discussion with the commissioners.
I would like to bring that up. I would like to see Bluegrass RV bring their final, that's what I'm looking for, final development plan back to the full commission.
I'd agree.
I just think that they're not being honest with us up front. We asked them to move the campers off, the campers are back on. I would like to see them bring it back before the full commission.
Do you need a vote?
Yes, please. And then a motion of, I'll make the motion, they bring it back. If someone second, Mr. Cannon will second. Can, all those in favor say aye?
Aye.
Those opposed. Mr. Langford, do you have any comment on that?
That was a motion to bring the final development plan back to the full board.
Yes, sir.
Just to review it, I guess, to make sure, I guess
I'd
some
like
people
to
have
see it.
questions.
I'll tell them.
Okay.
Okay.
Thank you, sir. I'm sorry we kept you here that long. We could have probably done that a lot earlier tonight.
I had a big speech, but now I'll make it if you want me to.
No, I'm ready to go home.
Good night, Mr. Langford.
Does anybody else have anything else?
You know, forget.
If not, meeting adjourned.